Thank you. You may take your seats. Good morning. Good morning.
Good morning.
I hope you're well. Welcome to the inaugural conference on the future of legal education, the long-awaited conference. Before we begin, allow me to lay down the protocols for this morning. Honorable Peter Kaluma, Member of Parliament for Homa Bay Town, representing the Speaker of the National Assembly. Ms. Rose Cave, the Deputy High Commissioner, the British High Commission in Nairobi. Professor Collins Odote, the Chairperson, Council of Legal Education in Kenya. Mr. Francesco Keki, the Team Lead of the UNODC Anti-Corruption Hub for Africa. Mr. James Manyonge, the Director, Legal, Compliance and External Affairs for the Financial Reporting Center, representing Mr. Saitoti Maika. The Council members of the Council of Legal Education. Professor Jack Mimali, the CEO, the Council of Legal Education. Ms. Faith Odhiambo, the Law Society of Kenya President, as well as the LSK Council members present. Mr. David Sigano, the CEO, East African Law Society. Professor Kameri Mbote, the Director, Legal Division, the UN Environment Program, UNEP. Honorable Gitobu Emmanara, the editor and publisher of the Platform magazine. Professor Pielo Lumumba, who's the former director for the Kenya School of Law. I believe he's on his way. Professor Kalundu Bitonye, the founding CEO, Council of Legal Education. Dr. Pamela Tibihikira, who's the director of Law Development Center of the Law Development Center in Uganda. Dr. Julius Mashamba, the deputy principal, Research from the Law School of Tanzania. The law faculty represented here, legal practitioners, the members of academia, and distinguished presenters and moderators. The members of the Senior Council Bar present, distinguished members of the legal profession in Kenya and in the region, as well as the members of the fourth estate represented here today. Ladies and gentlemen, good morning. I once again welcome you to the inaugural conference on the future of legal education and training in Kenya. Allow me to also recognize the presence of the following people in the room. Mr. Tweni Tupochile, who's our regional AML advisor in East Africa, and all the UNODC colleagues present. Mr. David Tor, who I believe, I'm told, is almost here, who's the Director for Legal Services for the Ethics and Anti-Corruption Commission in Kenya. Professor Ben Sihanya, from the University of Nairobi School of Law. Welcome, Prof. Dr. Ambua Kituku, the Executive Director, Kituo cha Sheria. Representatives of the Kenya School of Law. Representatives of the Commission for University Education. The CEO, National Council for Law Reporting, as well as the colleagues who are here who will be supporting by offering official rapporteuring for this workshop. Dr. Christine Agimba, the Chairperson for Kenya Law Reform Commission. Dr. Cecilia Ngaiza, representing the Dean, University of Dar es Salaam School of Law. Dr. Ivan Ngoro, representing the Dean, University of Makerere, Uganda. And other representatives from international universities. Just to mention two key presenters, we have Dr. Judith Olo from Robert Gordon University from the United Kingdom, and Dr. Atieno Mboya from Emory University from Atlanta, USA. Representatives of the International Court of Justice, I believe we have two representatives here. Representatives of the judiciary, the county governments, the Office of the Attorney General, specifically the Department of Justice, I believe I've seen somebody. The representative of the Office of the Director of Public Prosecution, Witness Protection Agency, representatives in the room, the Asset Recovery Agency, representative of the National Police Service, the Kenya University and Colleges Central Placement Service, COPS, the Kenya National Qualifications Authority, the Office of the Data Protection Commissioner, Kenya Copyright Board, the Advocates Complaints Commission, and members of the Legal Education Appeals Tribunal. I also recognize all the members of the professional bodies, the compliance experts in the room, the non-governmental organization representatives in the room, as well as our private sector partners. Karibuni, good morning. I hope you've had a good morning on your travel here this morning, and we welcome you once again. We are honored to have you here, and we are deeply, again, honored by the breadth of institutions that are represented in this room this morning. Your presence here reflects a shared commitment to strengthening the legal profession at a time when the demands placed upon lawyers, whether in the courtroom or in the governance space, are evolving with unprecedented speed. Now, over the next 3 days, we will go through a total of 13 structured sessions from your program. We have about 6 in panel session format. We have presentation of various conference papers and abstracts on specific conference themes. And we have 4 breakout sessions, which will take place, 1 in this room, and in breakout session room 2, which will be in the tent downstairs. Now, this conference seeks to interrogate the past, understand the present, and shape a future in which legal education responds effectively to the emerging realities of today. Allow me to briefly outline how today's program will unfold. We'll begin with, of course, this opening session from our leadership represented here today. We hope that this will set the tone for the 3 days, as well as provide some reflections, some historical insights from the top leadership of the legal profession that we have, and also provide some forward-looking discussions. Before we proceed, allow me to kindly share some housekeeping rules so that we are all, prepared. We request that our mobile phones are on silent mode throughout the session so that we're able to follow the discussions. We also request our speakers and our moderators to keep time, because as you can see, we're already running out of time. During the discussions, please signal any member from CLE or UNODC will be moving around with the microphones if you'd like to intervene. We'll have breaks, tea and lunch, which will be served downstairs and upstairs. But should that change, I will communicate that effectively. Restrooms are located inside to your right, but as well as outside, should you wish to take a quick bathroom break. Photography is allowed, of course, but please avoid using the flashlight during especially formal presentations. You have emergency exits in the room, which are clearly marked in case of any emergency. As I mentioned, we have 2 breakout rooms. This will be breakout room 1. If you will be attending the sessions in breakout room 1, you will remain here, and breakout room 2 will be in the tent downstairs next to the pool area. In terms of engagement, the participants or delegates are encouraged to actively participate in the sessions, engage with the panelists, ask questions, contribute to the discussions as much as you can. And with those few statements, allow me to invite our first speaker, Professor Jack Mimali, who's the CEO of the Council of Legal Education. Karibu, Prof.
Thank you, Jennifer. Honorable Peter Kaluma, the MP for Homa Bay Town, representing the Speaker, Ms. Rose Kev, the Deputy High Commissioner, British High Commission in Nairobi, Professor Collins Odote, the Chair of Council of Legal Education, Mr. Francesco Cecchi, Team Leader UNODC, the representative of the Director for Financial Reporting Center, Council members of CLE present, Mr. David Sigano, the CEO of East African Law Society, Professor Mbote, I think she's on her way, Honorable Gitobi Emmanara, other invited guests. Permit me to adopt the protocol that has already been set out for purposes of saving on time. Ladies and gentlemen, it is my distinct honor on behalf of the Council of Legal Education to welcome everyone at this opening session of the Conference on the Future of Legal Education in Kenya and the region. This conference is a call to reimagine legal education for the next decade with an unwavering focus on relevance, quality, and integrity. Our agenda is clear: to generate concrete proposals on curriculum reform, regulatory framework, skill development, and cross-border collaboration. We are here not just to discuss how to build consensus and craft actionable recommendations that will inform policy, but we are also looking at improving institutional practice in the legal education sector. The current state of legal education in Kenya is both an opportunity and a challenge to us. We have witnessed a remarkable increase in the number of law schools that are offering law programs in this country. Yet this growth has also brought pressing questions about quality, about access, about the opportunities that we have. And the debate around the number of advocates entering the market has been a concern that has been raised both in formal and informal settings. There are also quite a number of areas that needs to be addressed. There is the undefined paralegal career pathway and how people would then join in the legal profession in Kenya. There is the need for harmonization of the entry requirement to the law programs and to the ATP programs, all of which are challenges that are faced in the contemporary legal education provision. The legal sector itself is evolving rapidly. It is shaped by global complexity, financial systems, and technologies that are coming to bear. These trends have heightened the risk of money laundering, concerns on terrorism financing, and organized crimes. It is imperative that our legal education equips graduates with the competencies to meet these new challenges, and there is a call for integration of the emergence of AML, CFT, and alternative dispute resolution, as well as technology and ethics in the curriculum for training of lawyers. Ladies and gentlemen, we must also prioritize access to equality and equity and also diversity. Legal education must be inclusive, supporting students from marginalized backgrounds, persons with disabilities, women, and thereby reflecting the diversity in the society that we live in. Allow me to recognize the special guests and the participants, the representatives of the three arms of government that are here with us, from the parliament, from the judiciary, and from the executive. And also permit me to recognize the special role that UNODC has played in allowing us to have this conference to this day. We owe a special appreciation to UNODC for its steadfast support for strengthening the criminal justice system in this country and building capacities in the area such as counter-terrorism, anti-corruption, and anti-money laundering. The Council of Legal Education is committed to working collaboratively with the universities, with professional bodies, with the judiciary, with the regional councils. And let me pause to just recognize our partners from Uganda, LDC. On a very short notice, they were able to come, and we do appreciate that you are with us and you agreed to make presentations at this conference. I encourage active participations so that we may have a dialogue throughout this conference. By the end of the deliberations, we should aim to develop clear recommendations on the curriculum and the assessment reform, on regulatory improvements, and on roadmap to regional collaboration. The Council pledges to consider this resolution as we shape the future of legal practice in this country. Let us embrace constructive discussion. Together we can ensure that legal education in Kenya and the region remains as a beacon of quality and social responsiveness. So permit me to welcome you to this conference. I thank you.
Apologies. And another round of applause for Professor Mimali, please. He has offered a lot of thought leadership in the design and the entire planning process for this conference. So we really appreciate you, Prof. And we hope that the fruits of your labor will bear fruit today. So allow me to recognize the presence of Professor PLO Lumumba, who's just walked in. PLO, you are very much welcome. Feel at home. Karibu sana. Next, I'd like to invite Mr. Francesco Keki, who's a team lead for the UNODC Anti-Corruption Hub. As before he comes in, allow me to give you a brief bio of our team lead. He has over 20 years experience working in international organizations in the areas of good governance, public administration reform, as well as anti-corruption. Mr. Keki's work focuses on providing support to member states of the UN Convention Against Corruption for the implementation of the convention. He provides expert advice and input to the development and implementation of technical assistance programs in anti-corruption at the regional as well as national levels. The main areas of activities and expertise are in developing anti-corruption policy, laws, and regulatory frameworks, both at national and subnational levels, and providing specified technical assistance to specific independent agencies, line ministries, and other stakeholders within the criminal justice system. Welcome, Mr. Keki.
Thank you, Jennifer, for the extensive introduction, and thanks to all of you for being here today. Let me stand on the protocol that was laid out before me, but really appreciate all the distinguished speakers, chairpersons, the directors, everybody who's really here to help us starting this important dialogue. So ladies and gentlemen, distinguished delegates, colleagues, it's a real pleasure to join this inaugural conference on the future of legal education on behalf of UNODC and of the Africa Anti-Corruption Hub, which is located here in Nairobi. I would like to thank, special thanks to the Council of Legal Education for this partnership. It's great that we managed to pull off this conference. To the United States, INL, they are a great supporter of our initiatives. They are funding these activities. And I also want to, of course, acknowledge the UK, United Kingdom, FCDO for their support to UNODC for all the work that we're doing together in the area of anti-money laundering and other, of course. So this gathering comes at a pivotal moment for Kenya and the broader Eastern African region. The legal profession is confronting a rapidly changing landscape, one shaped by globalizations, digital transformation, expanding regional markets, and increasingly complex forms of transnational organized crime. As the conference concept outlines, the demands placed on today's lawyers stretch far beyond the traditional doctrinal foundation of legal education. This includes the ability to understand financial intelligence, to understand transactions, uphold integrity in environments where risks, opportunity, and regulatory expectations are constantly evolving. This is precisely why the anti-corruption and financial integrity agenda must now sit at the core of professional legal training. Under the United Nations Convention Against Corruption, state parties commit to preventive measures, criminalization, international cooperation, asset recovery, and technical assistance. Each of these pillars requires legal professions that is competent, ethical, and aligns with global standards. Lawyers are central actors in drafting legislations, advising public institutions, structuring transactions, representing clients, and shaping jurisprudence. More importantly, they are often the first and sometimes the only professionals capable of detecting misconduct, identifying the red flags, and preventing the misuse of the legal systems for concealment of corruption and or illicit assets. The Financial Action Task Force recommendations assign concrete responsibilities to lawyers as designated non-financial businesses and professions. Lawyers are expected to apply customer due diligence, understand beneficial ownership, understand the risks within high-value transactions, and ensure that legal services are not misused to facilitate illicit financial flows. These expectations directly shape national regulatory framework, mutual evaluations, and the overall AML CFT systems. So UNCAC and FATF are key fundamental strategic elements of the regulatory framework, and we really wish lawyers in the room and far beyond overall Kenya are well aware of these frameworks. As far as UNODC is concerned, our work in the region reinforces this very point every day. We have a regional anti-corruption platform for East Africa and the Eastern Africa Anti-Corruption Roadmap, whereby we collaborate with law enforcement agencies, FIUs, prosecutors, regulators, and oversight institutions. Across these interactions, one message consistently emerges. Long-term progress in financial investigations, asset recovery, and corruption prevention depends on the competencies we instill in law students, trainee advocates, and young practitioners today. This is why UNODC increasingly invests in partnership with universities, bar training institutions, and research bodies to support curriculum development, training of trainers, and development of practitioner teaching modules and anti-corruption and financial integrity. In this context, I am pleased to note that the UNODC GRACE initiatives, our global resource for anti-corruption education and youth empowerment, provides tools, material, and knowledge hub aimed at embedding integrity, ethics, and anti-corruption learning across primary, secondary, and tertiary school. GRACE offers university and law schools access to ready-to-use modules and academic resources that help integrate topics such as ethics, integrity, emerging technology, and corruption prevention directly into their curricula. So the program over the coming days, addressing AI, virtual asset, ethics, compliance, experiential learning, and regional harmonization is ambitious and forward-looking. It speaks to the need to produce lawyers who are not only globally competent, but who can actively contribute to national development, uphold the rule of law, strengthen public trust, and ensure that East Africa remains competitive in an increasingly integrated global systems. UNODC is committed to supporting this journey. We will continue to work alongside the regulators, education bodies, law schools, bar association, and development partners to strengthen financial integrity competencies, advance harmonized regional standards, and cultivate a legal profession that plays its full role in implementing UNCAC, FATF standards, and the broader integrity agenda. So I look forward to the discussion over the next days, and I wish you all participants a productive and inspiring conference. Asanteni, thank you very much.
Thank you very much, Francesco. Now, our next speaker is a veteran Kenyan lawyer, journalist, and human rights advocate, and the founder or editor-in-chief of the Platform magazine. He's widely recognized for his courageous defense of press freedom, democracy, and the rule of law, founding the One Bold publication, the Nairobi Law Monthly, through which he exposed injustice during the challenging political times in Kenya. He's a qualified advocate of the High Court of Kenya. Mr. Gobu Emmanara has spent years defending human rights and civil liberties. He has also served as a member of Parliament for Central Imenti constituency, contributing to Kenya's democratic and legislative process. Now, despite facing imprisonment and intense political pressure in his early career, including detention during the 1980s and early 1990s, for his outspoken journalism, Mr. Emmanara Honorable Emmanara, my apologies, persisted, earning international recognition for his commitment to freedom and the expression of justice. Welcome, Honorable Emmanara. Round of applause as he comes up.
Thank you very much for that introduction. Allow me to acknowledge the protocols as set out at the beginning and go straight to making my few remarks as requested. The theme that is the discussion point for this meeting: legal education and training for a globally competitive lawyers, reflecting on the past and charting the future. Last week, I think it was, when the Chief Justice admitted 900 lawyers, there was widespread discussion on whether we need so many lawyers or whether our economy can absorb that number of lawyers in any 1 year. I think that was a misconception. We do not train lawyers for Kenyans. We train lawyers for the world. And it is fitting that, in fact, the theme for this conference talks about the global village. So when I look at the Kenyan lawyers that serve internationally, I think we need more, not less. In my view, this misconception is as a result of, part of the reason being the curriculum that CLE adopts for training lawyers. And I think this meeting today should encourage the CLE to revise their curricula so that the core training can extend beyond the service to Kenya and serve the international community. I think it's time for the CLE to adopt a training curricula that serves the world. English, as important as it is at the international level, is just one of the international languages. And I think one of the areas in which we can absorb lawyers is training in the languages of these, for example, the United Nations Security Council, so that when we are called upon to produce experts, we do not give those who have run away and have got qualifications while in exile, but look upon the training institutions that are available locally to provide the expertise that is required. We sit here today even to acknowledge, for example, that one of our very own now sits at the International Court of Justice. I'm talking about Professor Phoebe Okowa. There are many other Kenyans who serve, but they're not serving as a result of encouragement from CLE. I think they're serving as a result of their own, perhaps, personal striving to be better and more competitive lawyers. So our role, not only as a government, but as the body that trains, supervises, and licenses lawyers, is to chart a course that enables Kenyan advocates, when they are qualified, to go directly to international service. And in this regard, the Ministry of Foreign Affairs perhaps should begin by ensuring that we have qualified advocates in all our missions abroad, in all the international agencies in which we are represented, and in all the teaching institutions where we send students. Indeed, when I look at the organizers of this conference and notice that the UN is involved, it just undermines, emphasizes the recognition that Kenya gets for our expertise in the legal profession. And we'd like to encourage this by offering not just funding for workshops such as this, but also scholarships for training of lawyers in more specialized areas. The Kenya in which we serve is striving to create a law-based nation, a nation of rule of law. So when I see 3,000 chiefs being recruited to serve under a written constitution that aims to abolish the provincial administration, I wonder what can we as lawyers contribute? And this will of course be a bit probably controversial, is that the chiefs have outlived their usefulness, and perhaps it's time for us to create a constitution enforcement agency at the grassroots, so that we replace chiefs with qualified lawyers who would be teaching the villagers the values of constitutionalism and rule of law and a law-based nation. That way, Kenya will not be forever be identified with repression and oppression, but as a nation that one can visit to see how a rule of law-based nation operates, where checks and balances are recognized, adhered to, and where the institutions of governance respect the checks and balances that are embedded in the Constitution. Because the essence of our constitutional democracy is rule of law. But in practice, we are not encouraging rule of law. We are encouraging the return of the old provincial administration. And perhaps the Deputy President and his representative who is here will perhaps let the powers that be know that we do not take kindly to measures that take us back to the days where Constitution or living under the Constitution was living under rights that were considered as privileges to be enjoyed at the pleasure of the executive. So as we go to the next 2 days, I'm looking forward to hearing how we can comprehensively review the curricula for the Council of Legal Education to incorporate the values that shape today's international community, the values enshrined in the International Criminal Court, for example. I'm currently involved in a lawsuit that we hope will end up at the International Criminal Court, hoping that those who hold responsibility for atrocities, I'm not talking about the president or the deputy, I'm talking about law enforcement officers who enjoy protection that has no basis in law, so that we can develop a culture that respects a rule of law-based nation. I end by encouraging us to speak openly and freely about the shortcomings that we face as a nation striving to fill a gap, not of absence of lawyers, but of obeying the principles of rule of law. I thank you.
Another round of applause for Honorable Gitobo. Thank you very much for the caution, but also for reminding us to reflect where we've come from and think about also where we're headed as a profession. Thank you very much. At this juncture, allow me to recognize the presence of Honorable David Ochieng, the Member of Parliament for Ugenya constituency. Mheshimiwa, you're welcome. Feel at home and karibu sana. Next, our next speaker is the President of the Law Society, Ms. Faith Odhiambo, who is also the former Board Secretary for the Federation of Women Lawyers in Kenya, FIDA. She serves as a lecturer at the School of Law at the University of Nairobi and teaches the law of business association, banking law, competition law, and consumer protection law. She's also a partner at Ombok and War LLP Advocates based in Nairobi. Madam Odhiambo has experience in litigation, corporate and commercial law, telecommunications law, and competition law. Her research interests and expertise are in competition law, consumer protection law, telecom, banking, financial services, arbitration and ADR, women and children's rights, climate change, human rights, and so on and so forth. Thank you very much. Karibu sana, Madam President.
Honorable Peter Kaluma, Member of Parliament and representing the Speaker of the National Assembly, allow me to adopt the protocols as were previously pronounced. Good morning, everyone. It's an honor to join you at this critical gathering where we confront one of the most important questions facing the legal profession currently. How do we prepare lawyers who can thrive in a rapidly changing world and uphold the promises of justice in Kenya and the East Africa? Let me begin by thanking our hosts, the Council of Legal Education and the United Nations Office on Drugs and Crime Africa Anti-Corruption Hub for convening this gathering and for deliberately placing legal education at the center of our regional reform agenda. I remember arguing with one of my mentors, the chair of the Council of Legal Education, before this forum was set, and we're asking ourselves certain hard questions with regards to the numbers we continue seeing, the complaints we get from the judiciary with regards to competence and capacity of some of the advocates, and regards to also their role in streamlining the curricula and legal education in this country. And for me, something that pains me greatly. If you had the opportunity of studying abroad, you would notice that over time, the requirements are growing for you to be able to qualify to take up your master's degree outside the country. A lot of questions as to the quality of legal education in the Kenyan system. We didn't have to sit certain English exams, now we have to sit them. And more they keep on growing. And so the question we ask ourselves is it that the standards outside have changed, or is it that the perception of the standards within this nation have changed? The decision to bring together regulators, academics, practitioners, students, and other international partners reflects a clear understanding that the future of the profession will be forged in spaces such as this. One of the core functions of the Law Society of Kenya as prescribed under Section 4E of the Law Society of Kenya Act is to set and maintain and improve the standards of learning, professional competence, and professional conduct for the provision of legal services in Kenya. This mandate is complementary to and facilitative of the regulative and supervisory role that the Council of Legal Education plays. Accordingly, we share in the consequential function of ensuring that we not only have the continuity of the legal education and profession, but more so that we provide legal professionals who are competent, innovative, and ethical enough to ensure access to justice and forge new frontiers of opportunity in the practice of law as we know it. Our theme today invites us to look back with unconstrained honesty and forward with optimistic vision. Legal education for globally competitive lawyers challenges us to reflect on the past, to account for the present, and to chart a future that strengthens both our legal systems and societies. John Dewey once said, "We do not learn from experience, we learn from reflecting on experience." This conference offers a moment of reflection and reimagination for legal training in the Kenyan jurisdiction. Legal education in our country has undergone immense transformation. Over a few decades, Kenya has faced a tremendous expansion in legal training institutions. We have moved from an era where legal training was a rare privilege offered to a small elite to a present where almost every region in the country has multiple institutions that offer legal education, a challenge that the CLE is facing today, and people are raising questions. A time when students of the revered the University of Nairobi were exempted from painstaking rigors of the Advocates Training Program at the Kenya School of Law, to a new reality where a girl from Catholic University of Eastern Africa had the unimaginable privilege of leading the Law Society of Kenya. This growth has created new pathways for people of all generations to enter the profession and has enriched academic diversity across our communities. 2 weeks ago, I attended the admission of the bar of some 920 new advocates of the High Court of Kenya. Among them were a few notable names, personalities that we have known in many other spaces and given several different titles, and yet they retained an inbred longing to have the privilege of knowing, interpreting, and practicing law. Sat in the same arena with hundreds of significant younger counterparts to be able to join the profession. Indeed, the exponential availability and access to legal education has opened doors to many who previously could not join the legal fraternity, not for lack of desire, but for lack of opportunity. This expansion is a story of progress, one that has widened access to legal knowledge and created a critical mass of legal minds in government, private sector, civil society, and judiciary. This expansion has made the bar more bold, vibrant, and secure in numbers than it has ever been. Yet it has also come with unprecedented challenges that we must now confront honestly. Classrooms have grown faster than capacity. The numbers have not always translated into readiness for modern practice, and curricula have not always kept pace with emerging global trends and demands. So that is the question we must ponder over. Does the standard of legal education we offer respond to the complexities of modern legal work? Are we building mere paper pushers who cannot leverage technology as a tool rather than a threat? Or are we producing the torchbearers of legal practice in the age of AI and blockchains? Friends, cross-border transactions, regional integration, digital economies, and transnational crime have reshaped what it means to be a lawyer today. Crimes such as money laundering, terrorism financing, and cybercrime require lawyers who understand not only the law, but also the risk management, client due diligence, financial intelligence, compliance frameworks, and technological literacy. Trends such as cryptocurrency, streaming services, and online work have redefined the business of law and completely shifted the goalpost on what one needs to succeed as a practitioner. These specialized niche skills are no longer optional, they're fundamental. In the history and in the world, I think the Law Society is the first being a regulator of anti-money laundering in the profession. And hence, these are skills now that behoves that every advocate must have, because the Law Society will be implementing the same. Evidently, therefore, it matters not that we welcome 2,000 new advocates to the profession every year, if it only matters that in every lawyer that graduates from our institutions, we ensure that they exemplify the quintessential competencies of a 21st century lawyer. One who can navigate global legal regimes with confidence, understand multi-jurisdictional commercial transactions, engage with complex financial systems, ethically and carefully apply technological tools in practice, and tongue-in-cheek, not use of AI that hallucinates and quoting non-existent regulations, conduct comprehensive client due diligence before engaging, and uphold ethical standards even when the landscape is uncertain. This call does not serve as an invitation to overload our curriculum with additional courses. It's a call to design programs that integrate thematic global trends into the fundamentals of legal training. For instance, what is the place of the canons of legal interpretation in a world where research is largely informed by artificial intelligence? How can we modernize perspectives on the law of tort in a world where the duty of care is often difficult to apportion due to non-traceability? We must train our students to be ingenious problem solvers and pathfinders, not sell to them a one-dimensional understanding of legal practice. To meet this demand, legal education must be interdisciplinary, innovative, experiential, and grounded on strong ethics. As Thomas Jefferson reminded us, whenever you do a thing, act as if all the world was watching. Ethics must anchor all training because global competitiveness without integrity is a danger to the society. At a time where corruption, illicit financial flows, and organized crime continue to undermine our states, lawyers occupy a unique position. We are both facilitators of transactions and guardians of legality. We are, to borrow the title of one of the sessions at this conference, lawyers as gatekeepers. If our law schools and professional training programs fail to instill integrity, courage, and the ethic of service, we should not be surprised when some of the members of the profession become enablers of the very crimes they are sworn to prevent. Professional ethics must therefore move from being a single course unit taught and examined once to a thread that runs through legal education and post-admission training. Clinical programs, moots, internships, and continuing professional development should all deliberately raise ethical dilemmas and require students and practitioners to confront them. Technology must also become a core component of training. AI, digital forensic, blockchain transactions, and online courts are redefining practice. We cannot prepare lawyers for an analog world when the world they enter is digital. The future of legal education must also be anchored in access to justice. Our region still bears the scars of inequality, historical marginalization, and ongoing human rights violations. If anything is to show you the recent events that have happened not only in this country, in Tanzania and Uganda. Many of our citizens encountered the legal system not as a source of protection, but as a space of fear and exclusion. If we are to deliver this dream, then the academy, the bar, and regulators must operate as partners and not parallel actors. The regulators must set high standards. The universities must innovate boldly and teach dynamically. The bar must mentor, guide, and demonstrate what ethical and competent practice looks like. We need structured collaboration amongst these actors. That includes regular joint reviews of curricula and professional training requirements, data sharing on skills gap and disciplinary trends, and joint programs on thematic areas such as anti-money laundering, countering the financing of terrorism, and anti-corruption. When these pillars move in harmony, we produce lawyers who can stand confidently in Nairobi, Arusha, Kigali, London, or The Hague. As Justice Benjamin Cardozo said, the law never is, but is always about to be. Our training must therefore anticipate the future rather than react to it. The discourse we have here today will shape the competence of our lawyers, the credibility of our institutions, and the trust of the public in our justice systems. Let us seize this moment to redesign legal education in a way that reflects our growth, responds to emerging threats, and builds a generation of lawyers who can compete, collaborate, and lead in the global arena. And I hope we have representatives from the judiciary. And if they are, I hope they're listening. To the judiciary, we continue to see a lot of petitions coming before you, and you continue breaking down the laws, setting them aside. And for me, my challenge that I see, the more you bring down a lot of the laws, the regulations that we try to put together, all you're doing is bringing the legal education to a race to the bottom. We do not see people going to challenge and the courts allowing reduction of standards in Uganda, in Tanzania, in Rwanda, but here in Kenya we have put it an open book. We want to ensure that our legal practice is destroyed. In this race to the bottom, you also have a place to play. So if you're facing incompetence, take a mirror and ask yourselves, what role has the judiciary played in that race to the bottom? And to the CLE, you now face the open challenges. As much as you bring opportunities and opening universities, we ask you to remember the greater importance of capacity to ensure that a fair chance is given to all students. Partners in the region, Kenya has opened its borders. However, reciprocity remains a mirage. And as we review our laws, it will not be far-fetched that this will soon be a criteria of admission to the bar. To ourselves, we'll be looking to taking up a more proactive role in working with CLE to ensure that we collaborate on the standards of legal education, on the curricula, the quality of education to advocates, and regional reciprocity, which has become a huge challenge that we now face with regards to the admissions we're having at the bar. In the words of Maya Angelou, do the best you can until you know better. Then when you know better, do better. Today gives us the chance to know better. The future will demand that we do better. The Law Society of Kenya stands ready to collaborate fully with the Council of Legal Education and all other stakeholders as we shape the future of legal training in our region. May our deliberations be frank, practical, and transformative. Thank you.
Thank you very much. Another round of applause for Madam President, please. Thank you very much. I think one question that has stuck with me is, does the standard of legal education respond to the modern day complexities? Thank you very much for inviting us to reflect onto some of the conference themes that we'll be looking at. We also acknowledge the good work that you're doing with the Law Society, with our colleague, I believe she is in the room, Madam Atweni. We acknowledge that you've developed some draft AML guidelines for the society, and we look forward to the launch and adoption as well. So asante sana. Now, I would also like to recognize the presence of Professor Patricia Kameri-Mbote, who is the director for the legal division at UNEP. Karibu sana. She also happened to be my dean a while back before she moved on to the UN. Welcome, welcome, welcome. Now we move on to Professor Collins Odote, our chairperson of the Council of Legal Education, who I would like to introduce before I hand over the rest of the program to him. So Professor Collins Odote is a chairperson of the Council for Legal Education, CLE, who was appointed on October 2023 to lead the Council's mandate of regulating, supervising, and licensing legal education in Kenya. He's an advocate of the High Court of Kenya and an accomplished scholar, serving as an associate professor of law and associate dean at the Faculty of Law, University of Nairobi, as well as the research director of the Center for Advanced Studies in Environmental Law and Policy, popularly referred to as KISLAP. He's a specialist in environmental law, land governance, and natural resource management. Professor Odote holds a Doctor of Philosophy in Law from the University of Nairobi, where he also earned his LLM and LLB degrees, alongside a Diploma in Law from the Kenya School of Law as well. He has contributed extensively to legal scholarship, policy, and the development of institutional reform, as well as, of course, his leadership at CLE, which has been marked by a commitment to strengthening standards, promoting innovation, and shaping modern, responsive legal education frameworks for the country. Welcome, Mr. Chair.
Our chief guest this morning, the Speaker of the National Assembly, represented here by my very good friend, Honorable David Ochieng, MP for Ugenya, the Deputy High Commissioner, the British High Commission, Honorable Rose Cave, Mr. Francesco Chechi, the team lead UNODC, Anti-Corruption Hub for Africa. Ladies and gentlemen, good morning. Please allow me to adopt the protocol that was very ably laid down by my former student and friend, Jennifer Guido. As we were discussing with Francesco, both him and I share something in common, that we do not like protocol. So if we try to read the names that Jennifer did, we'll definitely get them wrong. So I'm happy to say, please allow me to write on the protocol. Save that I would be failing in my duties if I did not acknowledge my teachers. Since we're discussing education, in this country, Francesco and Rose, we have reached a stage where it is not very easy to know whether people went to school or not, unless you have photos of your classmates and you can demonstrate who your teachers were. Professor P.L.O. Lumumba and Professor Patricia Kameri-Mbote taught me at undergraduate, supervised me for my master's, and Professor Patricia Kameri-Mbote supervised me for my PhD. So I can masquerade for many things, but I cannot lie that I never went to school. Any shortcomings, though, has nothing to do with their training. P.L.O. Lumumba also then taught me the practice of law in my very early years, and something that I'll be returning to in a short while. It gives me very great pleasure, colleagues, to welcome us to this inaugural conference on the future of legal education in Kenya and the region. And I will say so in a short while, but before doing so, please allow me to welcome you on behalf of the entire Council of the Council of Legal Education, and I'd just like to request my colleagues who serve with me at the Council to please just stand up so that you can be recognized. I see Sama Losa, and I see Professor Patricia Kameri-Mbote. Please sit. Sorry, and I see Professor Winfred Kamau. You know, Professor Winfred Kamau in another life is also my dean and my friend. So if I mistake her name, it is not out of bad faith. We also serve together with 5 other colleagues who are not here today. Rita Njiru, representing the PS of Treasury. We serve with Dr. Judge Smokin Wanjala, representing the Chief Justice. We serve with Oscar Reddy, representing the Solicitor General. We serve with George Nyakundi, representing the Attorney General. We serve with Professor Lois Musekali, representing private universities. We serve with Aisha Abdallah, who is out of the country, who together with Sama Losa, representing the Law Society of Kenya. So therefore, the Council represents the key stakeholders in this conversation. My colleagues, I'm extremely excited to be here this morning because a few months after I got appointed chair of the Council of Legal Education, we started the process of transforming the work that CLE does and how it does that work. And anybody who remembers that history will remember the very challenging period that I started with as chair. And I thank those who reached out to me. Professor P.L.O. Lumumba had conversations with me about how CLE can do its work better. At the heart of those conversations were several things, including how bar examinations is administered, including how we exercise our mandate of licensing and regulating legal education. But also critically was about what kind of legal education would we require into the future. And if you get the opportunity of looking at our strategic plan that we launched in April last year, I would invite you to look at the words that are then wrote as a forward to that strategic plan. Because in the third paragraph of my forward, I said, and I will quote, legal education for today's world must adopt to this new world and a new order of business. It must be bold enough to explore innovative tools and resources if it helps its graduates navigate legal issues with greater ease and confidence. Many countries across the world have begun to revisit their curricula on legal education and training. They have begun to rethink the knowledge and skills needed by the next generation of legal professionals. Those whose legal education focuses only on common law, for example, are slowly providing basic tools on civil law. I then said that the practice of law today requires agility, legal skills, ethics, professionalism, technological knowledge, and skill, all of which must be perceived as core outcome of any legal education and training. Therefore, signaling the need for us to rethink our legal education. And that rethinking, colleagues, is important because 66 years ago, in fact, it was in December 1959 going to January 1960, in the UK, and thank you, Deputy High Commissioner, for being here, around 60 delegates from across the world, Chief Justices, met in London, chaired by the very famous Lord Denning, to look at the future of law in Africa. I think 6 decades later, there's increasing evidence that we need to relook at the future of legal education in Kenya and in the region. Relooking does not mean abandoning. Relooking means improving, means questioning, means interrogating. And therefore, one of the things that I committed myself to do as chair was to host a Future of Legal Education conference. And for the last 1.5 years, we have tried and made promises that we are hosting the Future of Legal Education, until at some point it became a song with colleagues at the council that, Chair, are you really sure that this conference will be held? So I'm extremely grateful to UNODC for partnering with us to be able to have this conversation, because it's a conversation that is long overdue. Over the last 2 weeks, by some strange fate, academics, practitioners have been having very interesting conversations on cyberspace about quality of legal education. There have been conversations, and I think the President of the Law Society has mentioned it, that are 902 being admitted one go, too much. And who do they blame? The Council of Legal Education. But 2 years ago, colleagues, we were being blamed for the exact opposite, that CLE is a gatekeeper. They refuse to admit people, that they fail people. When you do exams, we just fail you. Now, when 902 are being admitted, we are also blamed. You are damned if you do, and damned if you don't. Number 2, a few weeks ago, there have been heated conversations on cyberspace about how many law schools are enough for this country. How many should we license? On the other hand, CLE told, you are not licensing people who apply. I can tell you applicants say, you are not licensing. In fact, Professor Odote, you are conflicted. As chair of CLE, who also sits at the University of Nairobi, you do not want any other person to be licensed. When people get licensed, we are told, you are licensing village universities. Colleagues, I invite you to look at the Legal Education Act and invite you to see what it asks us as our mandate. Our mandate is to consider every applicant and determine whether they meet the requirements of law. But I think the underlying conversation that we need to have, which is why this conference is there, is what kind of legal education providers do we require into the future? What kind of skills should they have? What kind of minimum requirements should they have? Because the state of legal education has changed tremendously from where it was when Professor P.L. Lumumba was teaching. We have an increased number of law schools offering LLB. As of today, we have 20 of them that have been licensed. And there are many other applicants. As of today, sitting before us, we have 7 applicants seeking also to provide legal education. So as you have the discourse, you must ask ourselves, from a regulatory point of view, what should the law provide more? What should the law provide differently? But we also have increased regulations, including from jurisprudence from the courts, on many things, on admissions of those that undertook their laws out of the country. We have conversations on whether in this age people should progress from diploma or not to do law, whether the minimum B requirements for English and Kiswahili is tenable in the current environment. We have conversations about decentralizing and devolving the provisions of advocates training program, court judgments. And those are things that we must be able to grapple with as a society, as a regulator. But we also have concerns about the quality of advocates entering the market. In fact, I've been telling colleagues who provide legal education that I think the challenge we have is not a competition between one law school or the other. The challenge we have is the overall assessment of our quality of advocates across the entire country. And that challenge is even more when you look at the increased number of non-lawyers who are self-representing in court and also representing others in court, and sometimes even doing a better job than ourselves. There are instances where, and the President of the Law Society is here, where there are people who have masqueraded as advocates, sometimes successfully for 2 years. So the question that it raises, what does that mean about our regulation? What does that mean about our training? When somebody who has not stepped into a law school, or as my former teacher and former Attorney General and Chair Emeritus of the Council of Legal Education used to warn us when he was teaching us that his duty was to ensure that when he looks at the class, he sees those of us who are much more suited to be butchermen, others who are much more suited to be farmers, others who are much more suited to be dancers. Nothing wrong with any of those things. But his duty was to ensure none of those people left the gates of university purporting to be lawyers. But now we have a situation where those butchermen, those dancers, those farmers, go to court, self-represent and represent others much better than ourselves at certain times until Faith and colleagues catch up with them for being masqueraders. Colleagues, if we look at the mirror, what does that mean about the quality of legal education? Question number one. Question number two, and Faith spoke to it, as we train lawyers, both at universities and at the Kenya School of Law, conveyancing is restricted still to conveying land in an environment where data, and I see my good friend Immaculate Kasait, the Commissioner of Data is here, is the new oil, where the subjects, the 9 P's that we teach, are principally focused on practice as being the practice that Gitobu Manyara knew, the practice where you practice at the Magistrates Court in Kibera. Nothing wrong with practicing at the Magistrates Court in Kibera. It now also has a high court by a very good friend of mine, where practice is at Milimani Commercial Court and Milimani High Court, and where practice is at the High Court at the Court of Appeal. In the 21st century, where majority of the lawyers practice everywhere else except those spaces, are we training for the market in the 21st century, or are we training for the market as it was then? Challenges for us to be able to address. Colleagues here have spoken about the regional perspective, globalization, commercial financial systems, and digital technologies increase the risk of money laundering, terrorism financing, corruption, and organized crime, all which demand new competencies from lawyers, prosecutors, judges, and regulators. As we have increased regional integration, as we have increased African continental integration, as we have increased discussions at the global space, despite the challenges that globalization is facing, the new lawyer is a lawyer that must be able to deal with questions about regional standards, mutual recognition of qualifications, and mobility of legal professionals. I'm glad the president of the Law Society spoke about it, because colleagues, we definitely have challenges around that space. But those challenges all being kept thrown to the doorstep of the Council of Legal Education. Even though, when you look at the law, there is what CLE should do in terms of administering the bar exams. There is what LSK must do. There's what the judiciary must do. And in the spirit of collaboration, we must stop the habit of pointing fingers to the next person. We must collectively find solutions that are fit for purpose. So that if we say we are going to have a reciprocal arrangement, it must be a reciprocal arrangement that we all respect. If we think there's a challenge, it must be a challenge that we all address and not ask CLE, what are you doing about it? We have nothing to do with reciprocity. Somebody else does. Please do it. So colleagues, as I end, what do I hope out of the next conversations? I hope that we can have a conversation about what kind of curriculum do we require. Is it a curriculum that is conceptual? Is it a curriculum that is practical? Let's look at what is happening in South Africa, for example. What kind of training do we require? Number 2, should law continue being a first degree or not? Number 3, what kind of pedagogy should we have for instructions of law? And number 4, what kind of areas of training should we infuse in our legal practice? I keep telling people that many years ago, when we were in school, every lawyer had to learn communication skills for lawyers. And something that I never understood, Professor Patricia Kameri-Mbote, HIV, AIDS, and the law as a common course. I do not know why we thought lawyers must learn about HIV, AIDS. And now that cancer is even worse than HIV, AIDS, why are we not learning cancer and the law? But in this modern age, if you do not learn technology and the law, you are definitely of the old generation. So we need to ask ourselves how we integrate technology and innovation in our teaching and in our learning. We also must be able to get ideas from you about how we improve our regulation and quality assurance. What can we do more? Is it about limiting the numbers? Is it about having greater standards? Is it about increasing regulations? We also need to ask ourselves the relationship, and I'm glad, I think tomorrow we are having the Commission on University Education. What is the appropriate balance between professional bodies and the Commission of University Education? How do we ensure that there's greater collaboration between the two of them for the purpose of improving standards? As we have these conversations, colleagues, we must keep in mind that students and young lawyers should not just be the subjects of our reforms, but must be co-creators of the future of legal education. Keeping in mind that the young of today are the old of tomorrow. So I see the former president of UNSA, who must now know that she is slowly leaving youth. So when you are young, please do not speak as if young is a permanent state of life. It is not. There will always be young people coming. So we must develop rules that are not just favorable for ourselves. We must develop rules that are trans-generational, that serve society in the long run. I'll be an extremely happy person when on Thursday, when we close this conference, we have been able to reimagine a future of legal education that is completely different from the one we have now. The one thing that will not make me happy is if we spend time lamenting, because the book of Lamentations is part of the Old Testament. The future can only be part of the New Testament. So please let us lament a little, but let us imagine more, because we expect as council that before we finish 2027, we must have contributed a lot to our vision of innovative legal professionals, transforming society, and also to the mission of improving the quality of legal education. And the ideas you give us today will be extremely critical in that process. I want to thank you and wish us all very well in our deliberation of the next 3 days. Please now allow me to welcome the Deputy High Commissioner British High Commission, Ms. Rose Cave. I am sure that the bio will be projected up. I know on this table we agreed that you will read the bio. She is the Deputy High Commissioner of the British High Commission. The rest of the things you will read. Please allow me to welcome her and thank you very much for collaborating with us in this process. Thank you very much, Mr. Rose Cave.
Ladies and gentlemen, all protocols observed. Habari za asubuhi. Good morning. Distinguished guests, the Council of Legal Education, members of the legal fraternity, academia, UNODC and development partners, thank you for convening this important dialogue. It's a privilege to represent the United Kingdom at this event, which comes at a critical moment as we anticipate the International Anti-Corruption Day on the 9th of December. Thank you to the Council of Legal Education and UNODC for organising this inaugural conference. Your leadership is shaping the future of legal education and professional training, which is vital not only for Kenya, but for the entire Eastern Africa region. The United Kingdom and Kenya share a deep and enduring legal tradition rooted in common law principles and a shared commitment to justice and the rule of law. This heritage has shaped our institutions and continues to guide our efforts to strengthen governance and uphold integrity. Legal education is the foundation of justice systems. It shapes the values, skills, and ethical compass of those who will interpret, apply, and enforce the law. Today, this foundation faces unprecedented challenges. Transnational financial crime, including money laundering and terrorist financing, corruption and governance deficits that undermine public trust, technological advancements and disruption, AI, blockchain, and virtual assets that redefine both legal practice and criminal typologies. These realities demand that legal education continues to adapt and that integrity, compliance, and global standards are embedded in curricula and professional training. Kenya's inclusion in the FATF Grey List underscores the urgency of strengthening compliance and integrity within the legal profession. Just a few weeks ago, there was a story in the news about a lawyer's involvement in a terrorism finance case using cryptocurrency. This case is a stark reminder that lawyers are not only interpreters of the law, they can also become gatekeepers, or in some cases could become enablers of crime. It highlights why legal education and professional training must embed anti-money laundering and countering the finance of terrorism obligations, ethical safeguards, and compliance competencies to prevent abuse of professional privilege and protect the integrity of the justice system. The United Kingdom is proud to support Kenya's efforts in this space. We're supporting various Kenyan institutions, such as the Financial Reporting Centre, the Institute of Certified Public Accountants of Kenya, and the Business Registration Services to address the FATF Action Plan. Specifically to the legal profession, through our partnership with UNODC, we are working with the Law Society of Kenya to enhance its supervisory mandate, mentoring staff, conducting sectoral risk assessments, and sensitising lawyers on compliance obligations. We're also working with other legal bodies in Kenya through our new programme, the Kenya Institutional Strengthening Programme, to address governance gaps in the legal profession more widely. These initiatives reflect our shared commitment to strengthening our legal professions so that they continue to be globally competitive, ethically grounded, and compliance ready. Legal education must evolve beyond doctrinal teaching. This is not optional. This is essential for producing lawyers who can navigate complex governance challenges and uphold the rule of law in a globalized economy. The efforts to harmonise legal education standards across the region will facilitate cross-border practice and strengthen collective resilience against corruption and financial crime. Regional collaboration is key because illicit finance knows no borders. As we approach International Anti-Corruption Day, let us reaffirm that integrity is not just a principle, it's a practice, and that practice begins in our classrooms and our professional bodies. The UK remains committed to working with Kenya and the region in this journey through partnerships that advance transparency and accountability. Together, we can ensure that our legal professions defend justice and the rule of law, protect financial integrity, and drive growth and security for us all. Thank you very much. Asante sana.
Asante sana. We can give another round of applause to the Deputy High Commissioner. Initially, I was going to introduce my nephew, who happens to be the Member of Parliament for Homa Bay, but he has left a short while ago. But although he has left, I was going to remind him of something that Professor P.L.O. Lumumba used to tell him, and to an extent myself, when we worked in the same law firm, and something that is important for this conference. Professor P.L.O. Lumumba used to tell him, Kaluma, if humility stands between you and greatness, and then he would repeat humility and add integrity. Colleagues, those two words are critical for what the British High Commissioner has just said. That as professionals, we must always ask ourselves, are we humble? Are we people of integrity in how we conduct ourselves? And the quality of education that we give future lawyers must imbue those two values. But it's now my very pleasant duty to invite our chief guest, who is representing the Speaker of the National Assembly. He is the MP for Ugenya constituency, which is somewhere in Siaya County. He is a member of the Speaker's panel. He's an advocate of the High Court of Kenya, and he reminds me he is also the party leader of the Movement for Democracy and Governance, MDG. The rest of the bio, I will not attempt to read because I know the Honorable David Ochieng too well, and I would rather speak about what I know than what has been written for me. An excellent debater and an excellent leader in this country. So please join me in inviting our chief guest today, the Honorable David Ochieng, representing the Speaker of the National Assembly, the Honorable Moses Wetangula.
Thanks a lot, Professor Odote, distinguished guests, Ms. Rose Cave. Like I said earlier, all protocols observed. I'm happy to be here this morning and to say that I wish I wasn't reading this speech. I wish I was participating as a participant this morning because I have looked at your program and I would love to stay almost 4 days because what you're doing is so not just timely, but so crucial if all of us in that profession are to exist the way we plan to exist when we join law school. What Prof didn't say is that he taught me. He didn't say that. There's a time I was chased away from school for being truant, and he picked me up. I was in fourth year at that time and gave me a job. And did research with him. I'm thankful to you for that. But because my job today is not to say my words, I'll read the speech of the Speaker of the National Assembly, the Honorable Dr. Moses Masika Wetangula, as given to me. So it's a great honor to join you at this inaugural conference on the future of legal education and training in Kenya and the East African region. I wish to express my sincere appreciation to the Council of Legal Education, the UNODC, African Corruption Hub, and other partners for convening this timely and forward-looking dialogue. Your collaboration reflects a deep understanding that the future of governance, justice, and economic resilience in our region depends fundamentally on the quality, integrity, and global competitiveness of the legal professionals we train today. Since independence, legal education in Kenya and across East Africa has undergone an extraordinary journey. What began as a system heavily influenced by colonial models has gradually transformed into a dynamic and a vast platform for knowledge, jurisprudence, and professional preparation. The establishment of regulatory and training institutions such as the Council for Legal Education, the Commission for University Education, and the Kenya School of Law, alongside continuous reforms in accreditation systems and the growth of our universities and bar training institutions, has contributed greatly to building a stronger, more coherent, and more accountable legal sector. As we reflect on the current state of legal education and training across the region, we recognize notable strengths that include robust regulatory frameworks, practical training through law clinics and moot courts in the universities, mentorship programs, and increasingly innovative pedagogy in universities. However, gaps remain, which include limited professional training capacity, a limited integration of emerging fields such as digital law, artificial intelligence, compliance, financial integrity and transnational practice, and the need for greater harmonization of professional standards across Eastern Africa. Sharing best practices and aligning curricula across countries and regional frameworks like the East Africa community will be critical in producing lawyers who are globally competitive and regionally mobile. Indeed, the environment in which legal practitioners operate has changed dramatically. Globalization has reshaped legal practice, while digital technologies such as AI, blockchain, and virtual assets have transformed both the delivery of legal services and the nature of criminality. Sophisticated transnational crimes, including money laundering, terrorist financing, cyber-enabled fraud, and illicit financial flows, challenge economies and public institutions across our region. These shifts demand a reimagining of how we train lawyers. Traditional doctrinal approaches, though foundational, are no longer sufficient. Our lawyers must be technologically literate, ethically grounded, and capable of navigating increasingly complex regulatory, commercial, and financial environments. Legal education must prepare modern lawyers for an increasingly interconnected world by integrating global frameworks, best practices, and emerging trends in training. This ensures they can navigate cross-border legal work, uphold strong ethical standards, and remain strategically equipped to excel as globally competitive professionals. Ladies and gentlemen, as we reflect on past achievements, it's equally important to chart a clear and ambitious vision for the future. The lawyer of tomorrow must be globally competitive, equipped with mastery of law, critical thinking, ethical grounding, and technological literacy to navigate complex legal environments. Legal education and training systems must embrace innovative pedagogy, integrate financial integrity and anti-corruption competencies, and cultivate cross-border practice readiness. And by so doing, we must ensure that our graduates are technically proficient, ethically anchored, and fully prepared to uphold the integrity of the profession, contribute to the rule of law, and compete effectively in regional and international environments. And to this end, we wish to acknowledge and commend the United Nations Office on Drugs and Crime, African Corruption Hub, for its vital support to Kenya's justice sector and legal profession. Through initiatives such as the strengthening court administration, promoting digitalization, advancing anti-corruption and financial integrity, supporting the judiciary in construction of law courts for handling terrorism-related cases, and expanding access to justice for vulnerable populations. UNODC has helped build the institutional and ethical foundations upon which our legal professionals operate today. For the National Assembly, legal education remains a cornerstone of our national development agenda. A competent legal profession strengthens the investment climate, facilitates economic growth, promotes investor confidence, and enhances the integrity of public institutions. Recently, the House enacted the Anti-Money Laundering and Combating the Financial of Terrorism laws, a landmark reform that brings Kenya into alignment with the highest international standards on financial transparency and counterterrorism. This legislation enhances the mandate of the Financial Reporting Center and strengthens coordination among investigative, regulatory, and enforcement agencies, ensuring that suspicious transactions are more effectively detected, monitored, and addressed. Parliament also strengthened the Narcotic Drugs and Psychotropic Substances Control Act by adopting key amendments designed to tighten our national response to drug trafficking and related offenses. These reforms increase penalties for possession and trafficking, define precursor chemicals and the scope of law enforcement officers under the Act, and introduce offenses that for officers who aid or abet drug-related crimes. In addition, Parliament passed the Virtual Asset Service Providers Act 2025, and this forward-looking law establishes a comprehensive regulatory framework for virtual asset and cryptocurrency service providers, strengthening consumer protection and promoting transparency in digital financial transactions. With this passage, Kenya positioned itself firmly within the global best practice for governing the rapidly evolving digital economy and virtual assets ecosystem. As Parliament, we continue to strengthen legislation relating to legal education and regulation of the legal profession. We remain fully committed to supporting policy recommendations that may emerge from this conference. Ladies and gentlemen, as we embark on these discussions, I encourage every participant to engage with boldness, clarity, and intellectual rigor. Let us seize this moment to shape a harmonized regional approach to legal education, one that reflects our shared economic aspirations and reinforces our collective commitment to justice, integrity, and ethical leadership. Looking around this room, and I have done so, I'm so inspired by the array of participants in terms of expertise, experience, and of course, the sense of purpose. The future of legal education, and indeed the future of governance, economic resilience, and the rule of law in our region and in the country rests significantly in our hands. And with this sense of hope and confidence, it is my honor to wish you fruitful and insightful deliberations during this inaugural conference on the future of legal education and training in Kenya and the East African region. And with those so many remarks, allow me also to declare this conference officially open. Thank you, God bless you, and God be. Signed by the Honorable Dr. Moses Wetangula, VGH, MP, and the Speaker of National Assembly. Asanteni sana. Yeah, I have my own personal views, Dr. Odote, which I'll write down and send to you and the conference organizers. Thank you so much.
Thank you very much, Honorable David Ochieng, for relaying the message of the Honorable Speaker, but also for being here. We appreciate you. And with that, ladies and gentlemen, I think we've come to the end of the opening session. We will be inviting you shortly for tea break, which we hope will take 20 to 25 minutes so that we come back for the very exciting high-level panel sessions that we have lined up for you. But before that, I would like to request that we take a group photo. We have set up a place downstairs, so we'll be inviting our high tables to first proceed downstairs, after which then we have a few members of the Fourth Estate present. I believe Citizen TV is here, KBC is here as well, and TV47 who would like to ask just a few questions on the conference, and then we can proceed for tea. So allow me to invite you for tea. But before that, I'm informed by CLE Secretariat that we have a few gifts for packages for our key guests today. So I would like to invite, in no formal order, I think we can begin with Mr. Francesco Keki. Please come to the stage, Mr. Keki. And I will be inviting the chair, Professor Collins Odote, to hand over a small gift package before we proceed. They're coming. Yeah. Oh. Yeah. No. Thank you very much, Mr. Keki, for your leadership and guiding us also through the formulation of this workshop. Asante sana. Then I invite Honorable Gitobu Emmanara. Yes. And I request the chair to stay on. Thank you very much. LSK President, Madam Faith Odhiambo, karibu. The Deputy High Commissioner, Ms. Rose Cave, we really appreciate your presence. Thank you very much. And our Chief Guest, Honorable David Ochieng. I see there are very many goodies, but I'm informed they're for the rest of the high-level representatives, and they will be sharing after the high-level panel session. Asante sana for representing the Speaker of the National Assembly, and thank you very much. And with that, ladies and gentlemen, we invite you for a short tea break. But first we proceed for the group photo, a quick interview with the media, and then we proceed for tea. Karibuni.
Kaba sous les millionnaires. Natacha Chometis Noir. Siko Nazaboka Mabama. J'ai mis ma Kokonzoni, Rachel Kokonzoni. Je sais mon chemin, grâce Liteli. Pablo Kini, Lasconi Munza. Nico Kai, formateur de boss. Mireille, Monteya Thierry Kouloula les célébrer. Zambé, Tatala Kisangata, Noto. Natala Binefini, Kozala Namawa.
More natural and more
when you have the perfect response in your head, but your fingers just can't.
Let's move for the group photo. Let's move downstairs. UNODC, CLE, kindly help me usher people downstairs.
Papa Nalébi, réponds-moi, pardon chérie. Cimetière réservé, Liboulou Basombi Kavo, famille Balembi, Kokonsolenga pour Naza mourante. Déjà, Papa Nalébi, réponds-moi, Moteba. Cimetière réservé, Liboulou Basombi Kavo, famille Balembi, Kokonsolenga pour Naza mourante. Déjà. Les heures des saveurs, Adolphe Mouteba, Gila Mouina, Caraboy. Nakoma ko vivre.
We have Professor PLO Lumumba. Again, is a prominent lawyer, an activist, if we may call him so, a public law professor, and he's known for his advocacy of Pan-Africanism and his anti-corruption work. We also have from LDC in Uganda, Dr. Pamela. I'm deliberately avoiding misstating her name. She's a distinguished Ugandan professional, currently serving as the director of the Law Development Center in Kampala, a role that she assumed in 2024. She is recognized for her extensive experience in legal education and quality assurance. She previously served as the chairperson of the Uganda Law Reform Commission, and she's currently the director of LDC. We also have a presentation of a paper from Professor Ben Sihanya, who is a distinguished Kenyan legal expert and academic, and he's known for his advocacy with a significant contribution to constitutional law, intellectual property, and governance in Kenya and in Africa. Again, he has been Dean of the School of Law at the University of Nairobi. And then joining us online will be Dr. Wambua Kituku, an advocate, a scholar, and a practitioner. He has worked in various entities, including as CEO of Council of Legal Education. He is currently the executive director of Kituo cha Sheria. So in terms of the presentation, perhaps the panelists can just have their mic and they can give us an overview of their reflection generally on the past, current, and future of legal education, not just in Kenya, but in the region. So I'll invite Professor Kameri Mbote, and then after that, Professor Lumumba, and then Dr. Hele. Thank you.
Thank you. Thank you very much, Professor Mimali, for the introduction. I think when you're called to a panel and you're asked to speak about the past, present, and future, one of the things that comes to mind is that you have been around a long time. And being around a long time also comes with both responsibility but also baggage. And I think one of the baggage that the people around this panel have is that there can be no problem with legal education in this country and their names do not appear. In the same vein, there can be no developments that they didn't contribute to. This is a kind of way of putting it. But if you look at the landscape of legal education, I mean, talking about the past, the present, and the future, this morning there were intimations of where our legal education is coming from the Denning report. And the question is, when the Denning report recommended a kind of legal education for our country, what kind of legal education did they recommend? And I'd like to surmise that they were thinking more of the apprenticeship kind of legal education. And if you look at legal education in Kenya, the scholarship, intellectual aspects of it took a while to take root, because a lot of emphasis was on training practitioners. And that is, of course, you have to understand that within a context, that when the colonial government was living, there was the urgency to leave a cadre of legal practitioners who would be able to service the nascent legal regimes, whether they were of property or of governance, and also to keep some rudiments of law and order. So that is one phase. Then there was also the fact that you couldn't have training of lawyers in all the East African countries. And so the marker of legal training was Dar es Salaam. And Dar es Salaam, many of the people who say they were trained in Dar wear it with some element of pride, because it's always the case that when you are trained before others, you think you received better training than those who come after you. But then the East African community broke up, and an issue arose: what was going to happen to the training of lawyers? So in 1968, I believe in Uganda, they started training lawyers, and in 1970 in Kenya. One of the things that one sees in the training of lawyers in Dar es Salaam, and I was looking at a book that was authored by professors at that school reflecting on 50 years of teaching law. There was a lot of ideology in the teaching of law. Law was not taught as bare bones. It had a soul. And the question that I always ask is, when law was taught in Makerere and in Nairobi, what is the soul that was imbued in the teaching of that law? And I will not answer that question. I would like you to think about it. Fast forward then to what we see. I think this morning, the people talked about numbers. They talked about the 920 lawyers who are admitted to the bar. Not too long ago, I was invited by one to her party, her dinner. And so I asked her, what is your P105 number? And she told me it was 25,000 and other numbers. And I know that I am not probably the oldest lawyer, but mine is just 1733. So I realized that you're dealing with many lawyers coming to the marketplace. The other thing that we see is many providers. Again, I have been privileged to be a dean of a school, but also to have worked on the founding of Strathmore Law School. And I remember at the launch of the Strathmore Law School, even then, and it was way back in 2012, there was still concern about the number of law schools. And the then Attorney General, Professor Githu Muigai, said something that has stuck with me. He said, let the schools bloom, they will find their level. And maybe that is what will happen. There are some that will fall by the wayside, and there are others that will sort of go up. So in essence then, having many law schools isn't the problem. The problem, I think, is what we teach, because when you talk about legal education, you have to answer what they call the 4WH question. What are you teaching? Who are you teaching? Where are you teaching? And you know, the where is, people don't think that it's an important question, but I remember the late Professor Magoha and the then Cabinet Secretary for Education, Matiang'i, asking us to go and see where people are being taught. And the question is, if you're being taught as a lawyer on top of a kiosk or a bar, Alosa, don't look at me. I am not throwing any stones anywhere. What kind of lawyer are you going to come out as? And you see, we then get very defensive. But we have to ensure that the people who are taught in a place where, when they come out, they can actually interact with others without a sense of loss. The other question, the other W question, we have asked who do we teach law? And I think that's what Professor Odote was talking about when he was talking about, do people have to, if you didn't get it the first time, can you go the long route and get a diploma, or even maybe start with certificate, diploma, and then go on to study law? And the question is, if we don't allow people to do that, what is the problem? And then there's the question of the B in English and all in Kiswahili. And many schools, for the longest time, muted the B in Swahili. And many of us just looked at the B in English until the Constitution, and then you have students who know their rights. And they are saying, but the rules say either a ne, or a B in English or a B in Kiswahili. So why are you not taking the ones who have a B in Swahili? And you know, this comes to a point I'd like to make, that our teaching of law is very colonial. We wouldn't want to bring Swahili because it then brings in locality. Yet, many people would access law if it was taught in a language they understand. So, the how do you teach is the next one. And again, this is something that the CLE has grappled with when it's been talking about the pedagogical approaches. And of course, when you teach students during the day and you teach students during the night, their needs are different. And I remember as dean advising parents that you can't have your 18-year-old daughter going to school with the 50, 70-year-olds, because learning isn't just about transmission of knowledge. It is also about interaction. So if you're 18 and you're learning with a man who is, or woman who is 80, in class your experiences are going to be the 80-year-old. And then, of course, that colors your learning. Then the whole question of the practical element of teaching. I think many schools now have externships, many schools use moot courts, legal aid as ways of instruction. But again, we are so rigid. We don't have the place of the professor, what's the name of that professor? The clinical professor. So there is a place for the clinical professor, the person who's been practicing law for doggone years and knows how evidence works. Do they have to have the PhD to teach in law or the master's, or can their capacity in the craft help them equip our students? So this cookie cutter approach we have towards who can be a teacher of law? Is it a time that we need to think about that? Then there is the issue of technology, and I think this morning the president of the Law Society talked about artificial intelligence, blockchain, robotics, and you know, Kenya is referred to as the Silicon Savannah. If you look at the training of many artificial intelligence models, it's actually done in Kenya. But artificial intelligence hallucinates and can give you wrong information. So technology is an enabler. It is not to replace a good training in law. In the space where I work now, I always say that a lawyer who's been trained well, because I am involved in both procedure and substance of international environmental law. And I say any lawyer who went to a decent law school should be able to play with the rules and should also be able to find new law. So don't tell me that because the plastics treaty is only being negotiated now, the lawyers don't know. They can go and read where others have done what they need to know. And that then also raises the issue of multidisciplinarity. Again, borrowing from where I work now, you can't teach environmental law just as rules. There is what we call the science policy interface, because the scientists will tell us, for instance, there's a hole in the ozone. What can lawyers do about the hole in the ozone? They need to work with those scientists to see how to deal with the ozone depleting substances. So if we don't embrace interdisciplinarity, multidisciplinarity, transdisciplinarity, we are going to be lawyers, and maybe Professor Sihanya, you remember Trubeck and Galanta, who talked about scholars in self-estrangement. Maybe we will have lawyers in self-estrangement. So to conclude then, I'm saying that we can't be teaching law in, after how many years of independence, 60, close to 64, in the 65, 63 actually, we can't be teaching it in the same way. How are we equipping the people we are teaching to compete in a globally competitive space? Remember, the world has become a global village. And it is not enough to say, I am from a developing country. I think you need to be able to stand up and argue your case. Look at what, again, Honorable Gitobu Emmanara was talking about. My classmate, Professor Phoebe Okoa, is now a judge of the International Court of Justice. She must, because she is an international law par excellence, she can compete. She was in the International Law Commission, which is the commission that decides what will become international law. That you don't become by just saying you studied law. You must be duly diligent to inform yourself some more. I thank you.
Thank you very much, Professor. Let me intervene by starting with examples. When we were law students, the mere fact that you are a law student meant that you are good. There was no debate about it. Because it is the very best that joined the only university at that time, the University of Nairobi. Today there are 20 of them. And I remember that it was very difficult to pass law examinations, and we were full-time students. Today, I see individuals qualifying as lawyers who I know are on full-time employment. and who in my view are fairly mediocre. I wonder how they achieve it. I'm talking about standards. I wonder how they attend the full-time pupillage and they get letters from their pupil masters that they are fit to be admitted as lawyers or as advocates. That calls into question what is happening at the level of regulation and supervision, which is the work of the Kenya School of Law, and of course the Council of Legal Education also does play a role. The second issue is an example, just to talk about standards. We are worrying about standards. Several years ago, when I was the director of the Kenya School of Law, I remember two individuals whom I'll not name because they are prominent public figures. They came to the Kenya School of Law asking to be exempted from either attending the pupillage program or certain subjects. We refused. A few years after I have left, I saw them being admitted as advocates of the High Court of Kenya. The question is, how did they go through the sluices, and who created those sluices that they went through? What is my point? There is a crisis in legal education. Professor Kameri Mbote will remember at the University of Nairobi when we were transiting to what then became known as the parallel program and later the module 2 program. We said there is a danger here. You are creating two categories of students. One are the mainstream, the other are the night schoolers. The night schoolers are the ones who will come by the night, like Nicodemus in the Bible. And somehow, by dint of some training, they would qualify. It has become worse since then. Jurisprudence, which is being taught perhaps because of the numbers, and Professor Sihanya is here, perhaps is being taught in the same manner that I was taught jurisprudence 39 years ago. We are now talking about cutting-edge issues within the community, East African Community Law, the Customs Union, the Africa Continental Free Trade Area, and everybody has talked about artificial intelligence. Are we still teaching them in the same way? In the East African region, the good doctor here will remember that we undertook to harmonize education at all levels, so that if I was a law student at Makerere University, and God forbid I had to move to the University of Nairobi, I would do so seamlessly. Today, our education system in Kenya is so confused and confusing that if you want to be admitted at Makerere, they doubt your qualifications, and the same with Dar es Salaam. So there is a sense in which Professor Odote and his team have a very difficult work to do. And it's so difficult for certain very practical reasons. Professor Odote said here that they are damned whether they act or whether they do not, and it's going to be so. The reality is there are regulations. But remember, one of the things that we undertook was that every county, and we have 47 of them, and there is appetite for creation of more of them, should have a university. And each one of those universities have their politicians saying that they must have a law school. So you are seeing 20 now. In the next 5 years, there'll be 47 of them. Ethnic universities, ethnic law schools. These are the realities. Not too long ago, I received a phone call from a university which is establishing a law school, asking me to lend my name to them as one of the faculty. And I'm sure Professor Mbote has received such requests. Professor Sihanya, I'm sure you have. Many of us received those requests. And they ask you to do that for a fee. You don't have to teach. You just appear in their list of lecturers so that the Council of Legal Education can approve. Those are the low levels to which we have sunk. That is the situation analysis. Going forward, therefore, what must we do? The tragedy of this country, and I dare say Africa, is that we do not finance our affairs. And let me be candid. Why should the Americans be funding a program that is designed to deal with our Council of Legal Education? Why? Why should the British be doing so? These are core things that we should be funding ourselves. The English saying is still true. He or she who pays the piper calls the tune. And I'm suggesting that next time we come here, there should be no USID. There should be no British. There should be, UNODC can be there because we also make a contribution. But these are realities. And when Professor Mbote says that we are still teaching law, we still say we are the common law. We still want to be guided by something called the Commonwealth. We still say that the common man is the man in the Clapham omnibus. That is how we are teaching law. We are still teaching law with street-on thoughts. Jurisprudence with Winfred and Joloise. We must style up. And we'll only style up if we begin to recognize that law must respond to the realities of our soil. And as I conclude, within the East African region, we must ask ourselves if we are creating one common market and we want mobility of professionals. The accountants, in my view, have done a better job than the lawyers. The architects have done a better job than the lawyers. The engineers have done a better job than the lawyers. What are we going to do if we are going to harmonize education in this region? We are talking about removal of tariff and non-tariff barriers within the Africa continental free trade area. Are we creating lawyers that are going to be in a position to litigate in those spaces? These are the questions, ladies and gentlemen, that I am requesting to be on the table. Very lastly, and I say this because when I was at the Law Society, rather the director of the Kenya School of Law, I asked these questions. We are now going into spaces where we are talking about mediation and conciliation. And at that time, somebody came from the United Kingdom and another one came from Canada. And they were teaching Kenyan lawyers conciliation and mediation, young boys. And lawyers sat there with over 30 years experience being taught mediation. And I said, you are sitting here being taught? I would accept if they are sharing their experiences. The time now is to use this cliche to decolonize legal education. Today, we are going to mediation. Those who are African justice systems. We are going to conciliation. Are we teaching these at the university? And if we are teaching them, are we teaching them from an Anglocentric standpoint or from an Afrocentric standpoint? Remember that the dispute being resolved in Kenya in our courts only constitutes 10% of all disputes. Most disputes are settled outside of the court system. So, ladies and gentlemen, Council of Legal Education, these are the issues that we must confront going forward, but it's not going to be easy. You are going to meet many headwinds, particularly in this day and age when our country is becoming more insular and also being responding to ethnic demands for populism's sake, which undermines meritocracy. Thank you very much.
Thank you very much. much. He doesn't like me, yeah? I'm not noisy like Kenyans. Again, I'm Pamela Tibikira Kaligera from Uganda. Director. Your mics don't like me. Director of the Law Development Center, which is your equivalent of the Kenya School of Law. I was very happy to receive an invitation, quite belatedly, but I had to come, and I'll tell you why. In Uganda, we are asking ourselves those very hard questions, Professor Lumumba, because we are in a crisis. We've accepted we're in a crisis, that we have spoken way too long about this crisis, and it's time to act. Let me paint a picture of what is happening. We share the same history as outlined by Professor Kameri Mbote on how legal education started in Uganda. However, we have had, there's nothing else to call it but an explosion of interest in people who wish to study law. Almost everybody wants to study law. The politicians particularly, who demand to get admitted to law school, as well as to your equivalent of Kenya School of Law, the LDC. At LDC, we have to have students are required to attend 90% of the classes or sessions for a week. How is a politician going to fulfill this? I recall in about 2018, Professor Lumumba coming for what was then a national discussion on expanding the Law Development Center. And then the conversation was to open up campuses. We did think that that was one way to solve the congestion at Law Development Center. And I remember, Professor, you said you regret it. You said that then. At that time, I was working for the National Council for Higher Education. And I remember thinking, but this is a solution. The numbers are too many for LDC, it's too congested. Let's just open up one campus. And you know what happens when you open one. Very soon, in quick succession, 2 years later, we opened another one in northern Uganda. And last year, we opened another in Mimali. Now that coincided with my appointment as director of the Law Development Center. And I was now saddled with this problem. I always believe you have to take responsibility when you're in charge. We had, LDC had been having what they were calling deferred admissions. So each year, they would defer about 600 students. So they're holding an admission letter. By the time you come to the next year of admission, you already have 600 slots gone. And so the problem was compounding. So last year, we had a backlog of 2,000 students. And I remember sitting there and thinking, no, I'm now the director. I must solve this problem. No one is going to solve it for us. Previously, we had had that aid. You know, first the Netherlands government came in, then World Bank came in, advising on what to do. We said, no, we've got to solve this ourselves. So we decided we're going to clear the backlog. How are we going to do it? Through having 2 intakes. That's what we did this academic year, and it nearly killed us. We quickly came to the conclusion that we can't continue like this. So last week, we had a national stakeholders meeting on what to do about legal education and training in Uganda. And this is what we came up with. I'm giving you this flavor because you can imagine when I saw this conference, I thought, oh, let's go get ideas, because we're in the period of consultation. So the Attorney General's office has come up with what they're calling the National Legal Examination Center Bill. What are the proposals? That LDC transition from training into an examination center. Basically, it release its dual mandate, which right now is both training and testing for the bar. That we have other bar course providers. That is a proposal. Open it up. And of course, that brings a lot of uncertainty. Many of the stakeholders are saying, what has happened at the law schools is likely to happen also with the legal practice training if we open up to several other providers. So currently we have 17 law schools with 3 in the pipeline. And they're not going to stop because somehow law is one of the cash cows of the universities. So every university wants to have a law program. The bill envisages that there will be examinations at 3 levels, and I'm coming here to what you're also facing here in Kenya, that we should have a pre-entry into the LLB, because there's now some doubts as to the capacity of students to be able to withstand the rigor of law school. And the national exams, because we have an A-level system, which then people sit a national exam to go into university. And there's doubts that that's enough, the testing is enough to then determine who gets into law school. So the proposal is that there will be a pre-entry exam for those who wish to go into law school, akin to the LSATs in the US. Having opened up to other legal practice trainers, there's a proposal to have a pre-bar exam to determine who should now be trained for the bar. And then finally, the 3rd level of a national bar exam. The bill has met quite a lot of interest in the country because it's an opportunity to think again. And now everything is on the table, all the options on the table, including whether law should be a graduate course. Because in Uganda, we now have about 7,000 registered advocates, many others who are not practicing. And the questions are starting to come that, do we really need all these lawyers? And if we do, given that almost anyone comes into law school, and we do have that sort of Swahili debate, because there are those who, for their A-levels, will do a local language, they'll do Swahili, they'll do Arabic studies, and somehow get into law school. The time I went to law school, which was 1995, you had to have history, economics, literature. Those were the sort of subjects that were considered. But liberalization came in around 1995, and now you can study anything and get into law school. Anything. So the question now for us, seriously being considered, is whether law should be a graduate program. Why? Because there's also the conversation that we need to have, and I think Professor Odote, you mentioned it, looking at the curriculum. There's a sense that perhaps we need to stop this dichotomy where you have the doctrinal education and then you go somewhere else for practical legal training. So the idea is that if we fused them, we integrated them, and you simply went to law school and after that you're tested, that might mean we need a different type of student to be able to do that, and perhaps law should be a graduate program the way it is in the US or Canada. As part of the preparation for that national stakeholders workshop, the LDC Management Committee took a benchmarking visit to India. And India does have its, peculiar conditions, which we thought we might be quickly sliding into because they have a huge problem with numbers. And for them, the integrated curriculum then works because you just teach everybody and then they go for a bar exam. Only that their bar exam is multiple choice, so almost too many people qualify, 70% passage rate. So they're also thinking about it. But I'll come lastly to the one thing we discovered in India, which also speaks to our own situation, where the Bar Council of India has been made so powerful that they can really determine how they wish for the profession to be trained. They have a proposal to have a National Higher Education Authority, which has said, the policy says, there are 2 professions which will not fall under that authority, law and medicine. The Indians have decided those 2 are too crucial, and we must have the professions at the helm of regulating them. Now, in Uganda, we have this problem between National Council for Higher Education and the Law Council. The Law Council has supervision over professional legal education, so LDC directly falls under it. However, the National Council accredits the law programs at the university. So there's this mandate fight. I was quite curious when I heard that I think it was Professor Odote again who said perhaps we need to talk about that collaboration. So I'm very curious to see what is happening here in Kenya, because I thought you had sorted it out by having Q, and then you have a council, legal education, council for the engineers, and that the professions are driving the regulation. That was my assumption. So it's interesting to see this, because we want in Uganda to strengthen the Law Council and let them have the final and absolute say on accreditation of law schools, because we believe that standards have dropped so much, also again because the National Council of Higher Education is made up of members who themselves are vice chancellors of these institutions. So they, it's about buddies. You accredit someone and they will accredit yours. So the standard of setting up law schools is not as stringent as it should be. So to give you a picture, this, yes, by December, we are supposed to have concluded our conversations on what's going to happen to the National Legal Examination Center bill. So right now we're at the tail end. By end of December, that conversation should have ended with stakeholders' views gathered and the Attorney General going back to Cabinet with a revised draft. So this conference is extremely timely for us in Uganda, and I'm listening very keenly to ideas to see how we could improve our system. And indeed, Professor Lumba did say, we met some years ago on trying this cross-border legal practice bill, and I think we quarreled and it ended. We didn't quite come to a landing on it, and we really do need to revive it, because there's a lot of movement now within the East African community, and it's really shame upon us that lawyers who are meant to be leaders are the ones who have failed to agree, while our sister professions, the engineers and the doctors, have, steaming ahead of us. So thank you very much.
Thank you very much, our esteemed panelists. Indeed, a very broad framework of the discussions that we must have in the next 4 days has been set. I have heard Professor Mbote mention that we must conceive the how, the what, and the who that we are dealing with in this situation. And she has alluded to the fact that our teaching is still very colonial, including in the context of how we teach. And in the same context, Professor Lumumba has said the same. He has alluded to the problems of the legal education sector in Kenya, pointing about concerns on daytime, evening teaching. He has mentioned the concerns of ethnic universities, even alluding to issues concerning lending of professors' names for purposes of accreditation, and a number of other challenges. Dr. Pamela has also given context, and it's gratifying to, at least in a sense, know that we are not alone, that Uganda is also facing the same challenge. They are also conceiving the legal education system in the context that we are. And that allows us for the opportunity of interaction. Quickly, I want us to move to a session where we will have 2 paper presentations. I want somebody to facilitate Professor Sihanya to make his presentation. We are just changing a bit of gear because we are setting context for what we are going to have for 3 years. I think, Professor, you... 3 days. 3 days. 3 years. 3 days. 3 days.
Don't mind.
Professor, you would want to... So as he moves to the platform, he's going to give a context on transforming legal education through intellectual property and science, tech, and innovation in Kenya and in Africa, to just again set the context for what we are going to have for the next 3 years. Prof.
Okay, good.
For the next 3 days.
Good afternoon, ladies and gentlemen. Yeah, so it was to be projected. If not, I see what to do because I have to. Yes, so my paper is entitled Transforming Legal Education through Intellectual Property, or IP, and Science, Tech, and Innovation in Kenya and Africa, or STIs, and STI as in Science, Technology, and Innovation. And I focus on 3 issues, 3-pronged approach inspired by the Holy Trinity, which is basically content questions on curriculum, structure questions of legal education, and delivery. But then there are related issues, which are like accreditation, licensing, regulation, which have been on the table, and which must be on the table, issues of assessment and evaluation, and basically recommendations. So first we conceptualize and problematize, as well as contextualize the questions, the key issues, such as what is STI, what is science, technology, and innovation. Basically, 3 broad aspects are biotech, nanotech, digital technology, but these then have sub-components, such as media, software, internet, including what people call the Internet of Things, artificial intelligence, AI as an artificial intelligence, and the blockchain, questions of big data, cryptocurrency questions are coming in, and these are raising important challenges to legal education and training, as well as the practice of law. Then intellectual property then is broadly divided into 2, basically industrial property and copyright, including industrial design, trade secret, etc., etc. And these are important in various ways in ETRIM. And ETRIM, I prefer to call it ETRIM, in terms of education, training, research, innovation, and mentoring. I know most of the time we talk about education and training, which is good enough, and that has been, we were reminded that partly because some of us are fossils or ancestors, we need to talk about I would say the present, the past, and then the future, because we cannot change, we cannot transform into the future without understanding the present and the past. So I know for a long time we've been talking about legal education, or just legal education, and sometimes we add training, but research is equally important, and so is innovation and mentoring. Mentoring being, for a long time I used to only hear about guidance and counseling, but this ought to be integrated into the process. I see that most of the laws, most of the policy documents still talk about mainly education and training, and do not sufficiently integrate the research, innovation, and mentoring components. Then related to that is a question of what are we dealing with? Those questions that Professor Mbote was talking about as the 4 W's, 1 H. They can also be, they are also related, they are very important really, and they can be also be related to the question of SCAVI. Skills, knowledge, attitudes, values, and innovation. And you'll realize that for a long time, the education system that we got from Britain, which Professor Lumumba rightly says we must decolonize, was separating skills from knowledge. The apprentices were only about skills. Know how to draft a plane. Just don't ask why you are doing this. Just you. After all, they also came from lower levels. You remember the apprentices that were being article clerkship training system in most of colonial Africa. You just know how to draft a demand letter. Don't ask too many questions on why you are doing this. what, etc., etc. Just do it. Then the few who are trained in law, and it was very difficult to be trained in law, ask James Seroney, ask CM Jarwins Kodek, ask the early lawyers. It was not easy to get those advanced training because you are going to ask too many questions. You are not supposed to ask too many questions. And therefore, for them, they knew quite a bit about the whys, but not, again, there has been a disconnect in the academy, in the bar, in legal training and even legal practice on the scurvy, on skills vis-a-vis knowledge. And I'm not even going to go to the attitudes and values. Oh no, they are important. They are important for this conference because we must ask integrity questions, ethical questions, are questions of the affective domain or attitudes and values. Because we can be very skilled, and sometimes we are skilled in how to craft a good way of how a third of the budget should be fake. And these are really facts which come sometimes from the Auditor General and others. Then more recently, I'm glad we are talking about it doesn't look familiar. Pierre, are you sure? Help me, please. It doesn't look familiar. So more recently, we, courtesy of the Presidential Working Party on Education and Research, etc., we have the new language, which is very important in this country. Competency-based education, and the T in bracket, training in bracket, and which is very closely related to objective-based, or outcome-based. Some people also have objective-based. And we are now asking some very relevant questions, which we need to talk about competencies, but we also need to talk about objectives, and we need to talk about outcomes. It's not an either-or. All these questions are important, and they can deal with the scurvy questions: skills, knowledge, attitudes, values, issues. Or some people talk about the cognitive domain, the psychomotor domain for practical aspects, cognitive for the doctrinal aspects, psychomotor for the practical or pragmatic aspects, and affective for the value-related issues. And for me, it's not a question of either or. It's a question of what combination at what level, not either or. We can't banish doctrinal. We must understand the whys, etc., etc. So these issues also arise when we talk at various levels. We try this. Okay. Accreditation. So accreditation, licensing and regulation is fairly recent. I remember that when we were in a task force established by Professor George Saitoti, chaired by Mr. James Kamunga, and I was his vice chair, we were asking questions why we didn't have accreditation and licensing questions in Kenya being placed in the policy and regulatory framework. I'm glad that this work is now being done. That was about about 2006, 2007. And there has been an issue about this issue of accreditation and licensing, the questions of the role of commission. Dr. Pamela, you raised the question of Commission for University Education vis-a-vis CLE. What is the role of the Senate in these processes of the various universities? Does it matter that the program is LLB or is it LLM and PhD on the other hand? Are these being treated as fully professional, or are they academic and some also professional? What is the place of recognition of prior learning and experiential learning, which I'm glad that the CLE, the regulations have scope for experiential learning, but it needs to be, actually that's an area that needs to be operationalized. There isn't sufficient detail on how to deal with experiential learning and how to certify it, etc., as well as the area of executive legal education. There is a mention, but there is no detail. Even the area of PhD, there isn't sufficient detail. So there are some questions that, but we know that quite a lot of work has been done in terms of policy and regulatory environment. We have asked those questions of Senate versus Council, etc. How do we deal with it? What is these issues of ranking? Would CLE regulate the issue of ranking, etc., etc.? The regulatory framework is evolving. Legal Education Act, and I know I want to cover as much as I can because of time, but I'm aware also that so many other colleagues have made some comments on these issues, and some of the details will come as we go along. So let me just focus on these issues of curriculum, content, structure, and delivery. Legal Education Act 2012 is key. And the one that has a lot of detail is called Legal Education, in bracket, Accreditation and Quality Assurance Regulations 2016. There is the STI Act, Science, Technology, and Innovation Act. This is the one that has a framework for NACOSTI, National Commission on Science and Technology, and Kenya National Innovation Agency, etc., etc. And for a long time, that is also the regulation that focuses on our research institutions like KEMRI, CALRO, etc., which are very, very closely linked to the... if we are to transform legal education and have interdisciplinarity, these are the questions that we will continue to be talking about. Universities Act, there is also case law, which Professor Odote talked about. The case law is quite robust in this area, whether at university level or at Kenya School of Law, CLE issues. Policy, we have seen the Presidential Working Party report, which I think forms a basis for the next stages, and I'll be asking some questions that we can help fill in the next 3 days. This conference, which are really important. Then there are intellectual property laws like on trademark, industrial property, and copyright, which are really, really important in us integrating IP and STI. There's an act which I must comment about, especially in the decolonization of not just education and training, which is important, legal education and training, but also of Kenya. Section 3 of the Judicature Act says up to the year 2025, unless it was amended this morning, that we shall apply English common law of the vintage of 1897. I always cry in class. 1897. Why must we tie ourselves, Kenya, to one English common law, 2 of 1897, or of any other country? That, to me, is an unconstitutional provision that if Parliament should really help us work on this. Why are we not talking about Afro-Kenyan common law and common law that is evolving over the years in many parts of the world? If we are to transform legal education, we must not be tied too much to those. That section is very dangerous. Compare it to Article 2 of the Constitution on the source of law. Then we have also told in Section 3 of the Legal Education Act that the objective of the Act is to promote legal education and maintenance of the highest possible standards. So standards, quality, and relevance are therefore very important, and to provide a system to guarantee the quality of legal education, especially with regard to the legal education providers. And the parameters for these are partly in the content. And as we now know, the Constitution, among the policy documents or guidelines, I find this, the Presidential Working Party report is very, very important. We need to work on. And the strategic plan, this strategic plan 2023-2027 of CLE has a lot of very important information and has hints on how to do STI. So we just need to do a little more detail moving forward. So those, and then you can also compare to other countries that have been mentioned, like Kenya, like Nigeria, South Africa, USA, UK. US, there's a lot still we can learn. The fact that we are talking about decolonization doesn't mean that we are now totally delinking from the world. It's different from delinking. It's just that there are certain challenges from the past. And lessons can be drawn which are positive, which are neutral, or which are negative from various countries. The Constitution has a very, very good framework that we should try to look at for purpose of this conference. Number one, Article 1 on sovereignty and self-determination. Rule of law, I mean, how we go about governance. Article 10, and there's a lot on values, which I can't mention all of them, including sustainable development, which is really, really key. Articles 43, 53 talk about education. These are very, very important as we do transformation of legal education. Article 100 talks about special groups, which we need to look at. The gender issue, the ethnic question, inclusivity issues. Article 201 talks about public finance and relevant principles that we need to adopt to deal with a lot of the challenges we have in public finance and financial services regulation. Article 232 is very, very important on public service values and principles, inclusivity, etc., etc. So those are some of the issues. Then, how have we responded to issue of core areas? How have the core areas in legal education addressed our constitutional challenges, our challenges in sustainable development? There's a list here which I wanted us to look at. Some of the core courses over the years that we have been talking about, you can see them. They have changed over. They have changed over the years. Jennifer, how are you? Technology should be an enabler. It's frustrating me. I don't know what war it has with me. Okay, take the area of degree, LLB, diploma, ATP, postgraduate, LLM, PhD, etc. I think the details need to be supplied there. What do I do? I wanted to go back. Okay, I was looking at a list here. Just get me to this list of core courses in the degree. There is core courses in the degree. This is core courses on the postgraduate. If you just look at this offering, look at this course offering. This is forward. So this is forward. This is back. Yeah. I wanted to just capture some issues of core courses at the degree level. Woe unto thee if you don't offer these core courses. Thou shalt not see the accreditation. I want us to start a certificate or renewal. These core courses, I think, at the time they were established, I think there was a good reason. As we move forward to transform legal education, we really, and most, these are offered at the degree level. What then this means is that many times you have very few, these are the core courses, all compulsory, then you have very few electives. You have to see how to work with the electives, and sometimes it can be difficult. So a lot of discussion needs to go there. But the other question, the more fundamental question I wanted to ask, how have we conceptualized and clustered these courses to say that this category deals with this set of issues. For example, questions of doctrinal, questions of procedure, and questions of what the practice and the final consumer of legal services also needs. Those are not always, those are going to be the challenges that we'll have to deal with. Because in the year of our Lord 2025, we don't seem to have a clear provision there for STI, as in science, technology, and innovation, either as a subject or intellectual property, or either as a subject or evidence that it is cross-cutting issues, because you may not have all the subjects that one wants to teach anyway. That one we have to accept. Then there are core courses at postgraduate levels. When we were in school, and that is just the other day, early in Kenya School of Law, early 90s, these were some of the courses that were mandatory. Late 80s, and maybe 99, 92. Some of the courses that we had to do 5. 5 were compulsory, 2 were optional, depending on whether you had taken them at the university. The 2 which were optional were company law and family and succession, so that if you had taken them at the university, you didn't need to take them at the Kenya School of Law. And some people used to call them bread and butter courses, also related concept. In the early 90s, that is a case where exemption started kicking in. And then there was the issue of exempted. If you had done those procedure-related courses at the university, you didn't need to go to Kenya School of Law. The last question that one would then ask is, how come that in a number of cases, some courses are repeated at university and at KSL, with sometimes more or less similar content, probably adding a little more on the procedural components. And I can understand the problem and the dilemma, where the issue of passing highly at Kenya School of Law or not passing highly is an issue either way, because some of the courses would have been done at the university anyway. What the ratios are some of the ratios are there for some of the courses in the accreditation in the relevant regulations on accreditation, and some need to be established. For example, on issues of PhD, etc., etc. Should there be issues for mandatory digital literacy? Should there be specific courses on SCI or digital aspects of the law? And how much should be cross-cutting? How much of these issues of AI, etc., biotech, etc., etc., should be in the other courses? Strategic plan reference there. Then we are told in section 23, subsection 2, that which allows legal education providers discretion to offer any other program that it may consider necessary, taking into account. I think this is a very good clause, because the development of society is important. So data and privacy issues, IP, media, and communication issues would come in handy. Then there is a question regarding KSL. What informs this idea that we must take all the 9 units in one at the end of the full? Can these be staggered, etc., etc.? Some of them are summative, some of them are formative rather than summative, etc. What are the issues regarding admin of the courses, the curriculum, the exam, etc.? Is there room for, how do you balance project work, oral exams, etc., etc.? Generally, the administration of the entire project. How are we looking at the workers, the employees? In most of these issues, I know that employees, labor issues sometimes belong elsewhere. But trainers of lawyers are aware that they're training the best in terms of academic and professional qualifications. They are aware they are training people who are going to make serious money, and that's really the motivation. But to what extent are the people who really live by the River Niger washing their hands with spittle, to quote Okonkwo's father? There are so many rights and welfare issues in the administration of these programs and the curriculum. We can, of course, integrate STI, and we can integrate IP, intellectual property, at various levels, either as subjects, individual subjects, or as themes that are cross-cutting. We can look at them. For example, take the question of intellectual property. It would help us deal with problems of counterfeiting, and counterfeiting is a very big market for to help us deal with anti-money laundering and the question of the proceeds, financing of terrorism, and to combat the financing of terrorism. Counterfeiting is known as one of the sources of funding in these areas. So let me be sensitive to this idea. There are also ethical questions, integrity questions, which will definitely arise at various levels of the training of the curriculum, in terms of its content, in terms of its structure, and in terms of delivery. And Chapter 6 of the Constitution can really guide us in putting in enough material on integrity, on ethics at the various levels, paraprofessional level like diploma training, professional level, degree and above, etc., etc. Because of the related time constraints, these are some of the issues that could go into the redesign of a curriculum at the various levels, the questions of pedagogy and andragogy as we move forward, even as we look at the Kenyan market, the East African market, the African market, with respect to the various policy documents, and the question of harmonization, the question of reciprocal treatment, reciprocal arrangements, as well as important questions of harmonizing the curriculum, delivery, and examination, certification, etc. Thank you so much for listening to me.
Thank you, Professor Sihanya. You can see that there are quite a number of areas that we really need to conceive if we are to set a future for the legal education training. I know Professor Patricia Kameri-Mbote had other engagements, and we are really, really grateful that you were able to join us and present. I know she'll be leaving us. Asante sana. Also, Professor Lumumba has requested, because he had other engagements, but they were able to give us the time, come and just set the stage for the discussion and conversation. As Professor Mbote said, if you have been there long enough, then you take the flag, but you also take the credit for what is happening that is good. And the fact that they have honored our invitation to be with us, we really appreciate. So as they will be leaving, we'll continue with the final panel discussion. That will be presented online by Dr. Wambua Kituku. I'm hoping that he's already in, and then he can make his presentation.
Good afternoon, Dr. Mimali. Can you hear me?
Afternoon, yes, we can hear you.
So, and I hope my presentation is projected. I'm not in a position to confirm from where I am.
We can project Daktari's presentation. I think I've shared.
Okay. So thank you very much, Professor, for inviting me to make this presentation. Maybe a few disclosures as well as disclaimers. I am the Executive Director of Kituo cha Sheria, which in a sense is part and parcel of the legal education and training framework in Kenya, in the sense that we offer externships to those students who wish to engage in legal aid clinics. I'm also a former CEO and secretary to CLA. And in that regard, I wish also to give a disclaimer that my presentation only touches on aspects of regulation of legal education and nothing more. So I'm more looking at the procedural aspects of regulation of legal education and training. I'm happy Professor Sihanya has looked at issues of content legal education in Kenya over the years, driven by various paths and motivation. During colonial period, it sought to preserve racial hierarchy within the legal profession, and this was reflected in the entry requirements into the profession at that time. Africans and non-whites were consigned to joining the profession as vaqueros, especially untrained court officials who nevertheless had been exposed to matters of procedure over a period of time. And also, regulation at that time reflected the minor role of lawyers in management of public life. And when I heard Gobu talk about the role of chiefs and the need to replace them with lawyers, actually the ascendancy of chiefs and administrative officials in domains of legal adjudication reflected the distrust which the authorities at that time had for lawyers and training of Africans to become lawyers, because they were seen to be likely to engage in politics, which was not acceptable at that time. As independence approached, we've all heard about the Law Denning Committee and why it was formed. And the idea was to then reorient training of Africans to ensure that as independence approached, there would be preservation of order and stability in the post-colonial state, but also maintenance of neo-colonial control through training of Africans in the English style and thought. I think Professor Mbote has also spoken to that. But then in the post-independence period, the focus of regulation changed a bit, and this was motivated by the tension that arose in trying to find the role of legal education in building a just post-colonial state, on one hand, but also the fact that legal education was intrinsically neo-colonial in its character, and it was more oriented towards supporting or reinforcing the status quo at that time. So the establishment of organizations like Kituo cha Sheria and later reflection in legal training curricula of clinical legal education was perhaps motivated by the need to have legal education imbue certain values and characters in law students, which were facilitative of building a more progressive and just society. And when Professor Mbote also talked about the ideological debates in Dar es Salaam University that later flowed into the Faculty of Law, University of Nairobi, those ideological battles were also about clarifying on the role of legal education in the post-colonial state. And then as in the 80s and 90s with the liberalization of education. Of course, the challenge now shifted and the focus of regulation became more about worrying about quality as well as the quantity of lawyers who are being produced through massification of not just university education, but also legal education in general. And this was highlighted in the task force that looked at legal sector reforms and published its reports in 2017. So then, the problem that this paper therefore looks at against that background is given that regulation of legal education is characterized by command and control approaches, which basically emphasize on prescription and punitive enforcement, this has created adversarial relationships between the regulators, CLE, Commission of University on one hand, and the regulated entities, universities, as well as the bar school in Kenya. And there's been a lot of litigation around regulatory roles, overlaps of regulatory roles, the role of the bar school in regulation of legal education, and the need to liberalize the bar school. So with all this, the question is responsive regulation more suitable to regulating the legal education in Kenya? And if so, under what circumstances? So now, what is responsive regulation? And in this paper, I'm guided by the theory of responsive regulation, which was advanced by two professors, Ayers and Brainwhite, and they conceived it as a middle ground between the mandatory state regulation, which is characterized by command and control approach on one hand, and on the other hand, laissez-faire market regulation or deregulation. And if I'm not wrong, Professor Mbote here mentioned an attitude, a regulatory attitude towards laissez-faire. Let law schools bloom. The market will sort out the law schools as we move along. So yes, so then responsive regulation then comes in to provide regulators with discretion and latitude to adopt regulatory strategies that fall within a long continuum where at one end you have the command and control approaches, on the other hand you have laissez-faire attitudes. And it's meant to ensure there is trust, dialogue, cooperation, and restorative justice within the regulatory process. And in responsive regulation, regulation is viewed in pyramids, and the pyramids can be descriptive or they can be heuristic, that is normative. And let me start with the normative one. What ought to be the goal of responsive regulation? And the first order regulation is that regulation in order to achieve compliance. So at the first point of regulation, the pyramid should be broad enough, allow the regulator as well as regulated entity latitude to comply. But as you realize that there's less and less compliance, then you move up the pyramid, have more intrusive regulation in order to seek compliance, but at less frequency. The second order of regulation, from a normative perspective, is that the institutional arrangements should provide more plurality, industry citizen participation, and where possible, forgiveness in order to ensure compliance. But then, as instances of non-compliance are witnessed, then we should see more and more restrictive regulatory approaches as well as more restrictive regulatory appointments. In other words, where no compliance is seen, then we need to see emergence of command and control approaches at the top. Then the third order regulation is that it should provide, give regulated entities more freedom to less if no compliance is achieved. Now, in terms of the descriptive utilization of this theory, 4 strategies have been distilled. One is tit-for-tat enforcement, and in this case, regulatory design should be characterized by ever-increasing intrusiveness with ever-decreasing frequency. Second is tripartitism, where there is empowering and involvement of citizen interest groups in the regulatory design to avoid capture, because if you leave regulation as a matter of regulated entities and the regulated entities, because of the resources they have, could end up capturing the regulator and with negative consequences. Then there is also the idea of enforced self-regulation, and this is where the industries are allowed to set their own standards, but have those standards publicly ratified and probably deposited with the public regulator, so that in the event that there is no compliance with the industry set standards, then the regulator can come in forcefully and enforce those standards. Then lastly is partial industry intervention, and this is where resources are constrained and where there are too many entities to be regulated, rather than have regulations covering all entities in that sector, just focus on the most critical entities, use the regulatory law to regulate them in the hope that they will emerge a tightly regulated group that performs very well across the industry, and therefore it will stimulate a race to the top among even those who are not subject to the industry regulation. So, but I need to issue a word of caution that even though a responsive regulatory approach and theory is very attractive, and indeed empirical evidence studies have been conducted which show that where responsive regulation has been adopted, there's been better compliance and there's been lower costs of enforcement, leading to better standards. That notwithstanding, this approach may be limited in a complex regulatory setting, especially where you have varied regulators. And in our case, where you have CLE also overlapping some of its mandate with the CUE. So if CLE decides to adopt a more responsive in a rather long continuum of strategies and normative prescriptions, then it is also difficult to study because it's complex in itself and rather ambiguous. And therefore, it's not easily possible to set conditions under which it could perform better or worse than other regulatory approaches or strategies. So is there legal grounding for regulatory theory in Kenya's jurisdiction? I would say yes. Article 10 of the Constitution that provides for public participation, indeed, we could say is a norm that anchors, it's a constitutional norm that anchors regulatory theory, in the sense that, and even courts have considered Article 10, and they've held that within the regulatory process, participation must be genuine, reasonable, and meaningful. And also, the Supreme Court has also held that even with the licensing, participation is essential in the sense that it ensures there is no capture of regulators by private interests and with adverse consequences. And this was held in the Communication Commission of Kenya and others case of 2014. Also, Article 232 of the Constitution requires public service as well as state cooperation, including regulators like CLE, CUE, to embrace responsive service, public participation, accountability, and transparency as cardinal values in the discharge of their mandates and responsibilities. So then, within the legal education framework, is there room to anchor responsive regulation? If you look at Objective 3 of the Legal Education Act, it enshrines as one of the objectives the promotion of legal education and maintenance of the highest possible standards. And this, one could argue, could therefore anchor the work of CLE in promoting responsive regulations. How? Because responsive regulation requires ensuring the regulated entities know what the regulator wants, and therefore there's a lot of emphasis on capacity building, there's a lot of emphasis on research, there's a lot of emphasis on self-regulation, encouraging, incentivizing excellence, and therefore compliance. These are promotional mandates that can be read into Objective 3 of the Legal Education Act. The CLE itself, the board of CLE is established as an independent regulator, and that is very important for responsive regulation in the sense that theoretically CLE is shielded from elite capture or from regulatory capture. The composition of the board also includes industry players, both from private and public sector universities, and this is in line with the second order regulation heuristic, which calls for industry actors to be part and parcel of the regulatory scheme or framework of decision making. Then the duty of council to cooperate with other regulators and stakeholders. One could also say that, this promotes co-regulation approach, which is critical to responsive regulation, but also the provision that the board of CLE can invite experts to sit in its board, provide technical guidance without a vote. I think that's also undergirds this approach of co-regulation if implemented. In the regulations of CLE, particularly on accreditation and quality assurance, there is an important requirement there for self-reporting on compliance by the regulated entities. As part of renewing their licenses, they are required to state to what extent have they complied with the set standards. Are there instances of non-compliance? What explains those instances and what is being done to ensure compliance? And this is a cardinal characteristic of self-regulation, which could be construed as part and parcel of self-regulation, of responsive regulation. And then also engagement of stakeholders in curriculum review by universities before seeking accreditation by CLE. Again, that can also be seen in that light. But then, are there gaps within the legal education framework which could undermine a responsive regulatory approach? Yes. One is the promotion mandate that I talked about, that's enshrined in Section 3 of the Legal Education Act, has not been operationalized in law and in practice. Like, for instance, when I looked at the strategic plan, as well as the previous two annual reports of CLE, there's little that has been done to build capacities of regulated entities in order to improve compliance, and that in itself means that the regulated entities may not necessarily be aware of the expectations, nor may they maybe there could be gaps, technical or otherwise, that could get them not to apply. Then also they need to raise awareness. You don't see awareness programs or awareness creation programs reflected in strategic plan and also incentivizing excellence. I think Professor Tihanya talked about the issue of ranking. One way of positively looking at ranking is that it's a mechanism of promoting excellence. But of course, it has its own downsides. But maybe it could be one way of looking at this aspect. Then the lack of low student-centered focus in the institutional arrangements of CLE could also be another gap. And if you read the More University versus CLE decision, much of that litigation was anchored on the rights of students, particularly the right to education. So in a sense, what the court was telling the regulator, CLE and CUE, is that they need to embrace a student-centered approach from a rights-based approach, in making whatever regulatory decisions they need to make. So one way of ensuring this is perhaps looking at the composition of CLE and figuring out, should there be student representation, low student representation, or bar student representation, and if so, how? And should there be legislated consultative mechanisms that bring the students to the table, besides, of course, the universities and other legal education providers? Then also, there is no recognition of self-regulatory arrangements and engagement of legal education providers as such. There exists a forum for law deans or deans of law schools in Kenya that has been operating for some time, but it does not enjoy any form of recognition, and therefore that could be a gap. There is no public participation in licensing requirements for legal education providers. In fact, if you look at the accreditation and quality assurance regulations, the licensing part is basically a conversation between CLE and legal education provider. And when you hear people raising concerns about the number of universities that have been licensed by CLE to offer law, had there been public participation, public notification, public consultation, probably these concerns would not have arisen. Then lastly, the withdrawal of the University of Nairobi Faculty of Law from the licensing process of legal education providers. I think this should be a point of concern, especially noting that no escalated regulatory response has been seen from CLE. And this could present a legal quagmire of sorts. Supposing 4 years later, students from the faculty wish to join the Kenya School of Law, and they've graduated from a university law school that is not accredited by CLE. Would the Kenya School of Law or any bar school at that time admit them lawfully? So that's something that needs to be Sorry, you lost me. Hello?
Yes, we can hear you now.
Okay.
Daktari, we can hear you. You can summarize because of time.
So let me just go to the recommendations. One is, okay. Right. Now, recommendations, number one is the promotion mandate of CLE should be enlarged and supported. We should see more of these promotional engagements or activities, building capacities of law schools. There was an idea to have CLE develop core teaching materials for the bar school and things like that. I mean, those are the promotional activities that we have in mind. Research studies to look at the catchment potential for law schools in Kenya, so that any licensing decisions are made on the basis of such a study, etc., etc. Enlarge the board of CLE to include either students or bar school representation, so that the student voice can be heard, and provision of consultative mechanisms for students. Acknowledge self-regulation to provide role in setting and enforcement of standards. And in this case, perhaps Kenya should consider either moving a little bit more towards the approach embraced in the regulation of legal education in the US, where essentially accreditation is left to non-government organizations, like all voluntary accreditation processes anchored within the bar associations, which are non-statutory bodies. Same thing is in Canada. UK is also moving more towards soft law, smart regulation of legal education. Maybe those are ideas that could be considered. Or consider a regulatory opt-in and opt-out scheme for legal education providers. Those who feel uncomfortable be regulated by CLE, or CLE can allow them to come up with their own regulatory framework and supervise it from a distance. And if it realizes that there is little or minimal compliance, then as a statutory regulator, they can come in with a command and control approach and ensure compliance. Then provide public participation in licensing of law schools. I think I've talked about this. But then they also need to clarify the framework for escalating regulatory actions. The responsive regulation, as I said, is supposed to operate in a pyramidal fashion, where at the bottom of the pyramid, a lot of freedom is given to the regulated entities. But as the levels of non-compliance are witnessed, then the regulatory actions are slowly and progressively escalated until it reaches a time when it's only command and control. Prescription and punitive sanctions can be employed in order to solicit or elicit the highest level of compliance. And with that, I wish to stop there. Thank you.
Thank you so much, Daktari, for the presentation. I know we are running out of time. It's already past 1:30. There was a session that would have had just after this that would have led us to lunch, but we are running a bit late. The session that we have had was just intended to set the tone for the conversation that we must have as we look at the future of legal education in Kenya and in the region. I propose that we shall break for lunch, maybe for just half an hour, so that when we resume, we'll have that session that was supposed to be there before lunch. And then it will run for an hour up to about 3:20, after which we'll have the breakout sessions so that we are able to catch up with the program for the day. So I know there was a gift for presenters, most of whom have already left. So what we'll do, I know Daktari is still with us. We will probably have a session that we will then present them. Jennifer, you can take over and then allow us to go for lunch. Thank you.
Thank you very much. I think we will appreciate those who are still here. So I see Professor Sihanya and Dr. Pamela. If you may please come forward. And as they come forward, please, round of applause. We really appreciate your presentation. And for those who have also left us because of time, I once again would like to invite Professor Odote to come forward and hand them their small token of appreciation. This side, please. We'll begin with Dr. Pamela from the Pearl of Africa, we call it. Asante sana, round of applause, please. Thank you very much. And our very own Professor Ben Sihanya, thank you very much for that lesson and refresher. Thank you very much. Thank you very much. So lunch is served upstairs at the Chinese restaurant. Colleagues are at the door. They will pass you meal cards as you walk out. See you in 30 minutes. Legal Appeals Tribunal, the Legal Education Tribunal, as well as Madam Caroline Kasoa, who's a council member for LSK. Now we proceed to the second session, which is a panel discussion on integrating AML, CFT, and financial integrity into legal education. We will be looking at how the financial Task Force recommendations and the UN Convention obligations, among other treaties as well, can shape the legal curriculum and professional training. This session will be moderated by my colleague, Ms. Atweni Tupochle, who's our regional AML advisor. As she comes up, allow me to give you a brief bio of who Madam Atweni is. She's an accomplished Malawi-born lawyer and former Director General of Malawi's Financial Intelligence Authority, which she worked to establish in collaboration with the U.S. Department of the Treasury. She is internationally recognized as a champion for her role in bolstering Malawi's capacity to investigate financial crime and her contribution to international cooperation in anti-money laundering. As the first DG of Malawi's FIA, Atweni developed a strong cohort of financial investigators and analysts, this despite political turbulence, resource constraints, and security concerns. And in a context of high levels of corruption, the country was rocked by the Cashgate corruption scandal, which I believe we've heard of before, poverty, and large informal cash economy. She'll tell you more about herself, but please help me welcome Madam Atweni Tupochle. Another round of applause for Madam Atweni, please. Madam Atweni will be joined by Mr. David Tor, who is a Director of Legal Services and Asset recovery from the Ethics and Anti-Corruption Commission. Mr. Tor holds an LLB degree from the University of Nairobi and a Master's of Business Management, an MBA, executive degree from Moi University. He's an advocate of the High Court of Kenya and has practiced law for over 25 years. He has worked in the anti-corruption field for over 15 years, and he currently serves as the Director, Legal Services and Asset Recovery within EACC. A round of applause, please, for Director for joining us today as well. Also, help me welcome Mr. James Manyonge, representing the Director, FRC, who is a seasoned legal compliance and AML CFT specialist with over 30 years of experience as an advocate of the High Court of Kenya, spanning both private and public sectors. He currently serves as the Director, Legal Compliance and External Affairs at FRC, where he has been central to shaping Kenya's AML, CFT legal and regulatory frameworks. James is deeply engaged in the work of the East and Southern Africa Anti-Money Laundering Group, SAMLAG, having served as on multiple country assessment teams, and currently co-chairs the review group overseeing post-evaluation implementation plans of a SAMLAG member states. Please, round of applause for Mr. James Manyonge. Now, those two are also joined by two other panelists who will be presenting their conference papers. We begin with Ms. Diana Ogega. She's an advocate of the High Court of Kenya as well and a certified fraud examiner, specialist in economic crime. She's currently a PhD candidate within the Department of Criminal Justice at the UWC Faculty of Law, where her research examines the criminalization of public procurement fraud in Kenya. She also serves as a graduate lecturing assistant at the UWC Faculty of Law, where she supports teaching in administrative law. Her interest in data-driven approaches to fraud detection is supported by practical skills in tools and languages such as Power BI, Alteryx, and Python, where she employs to improve evidence-based decision-making and governance. Karibu sana, Madam Diana. Round of applause for her, please, as well. And last but not least, on a special note, I'd like to appreciate Dr. Eric Kibet, who's, like myself, an alumni of the Alliance High School. We know each other when we see each other. Welcome, Dr. Kibet. He's the Dean, Zitech University School of Law, and is a distinguished legal scholar, advocate, and academic leader, serving as the Dean currently at Zitech. He holds an LLD from the University of Pretoria, an LLM from Boston College Law School, and an LLB from the University of Nairobi, as well, of course, as a postgraduate diploma at KSL. He's a respected expert in constitutional law, human rights, governance, legal theory, and many other areas. He has published widely and contributed significantly to the legal scholarship and justice sector reform in Kenya and the region as well. Round of applause for Dr. Kibet as well. Karibu sana, Madam Atweni, I hand over the panel to you.
Thank you very much, Jennifer. So it's interesting, the topic that we have this afternoon, talking about AML, CFT, anti-money laundering, and combating the financing of terrorism, and integrating this into legal education. In Kenya, the issue of anti-money laundering and combating financing of terrorism has gained prominence over the past 2 years or so, following Kenya's grey listing. I'm sure many of you are aware that Kenya is on the FATF grey list, the Financial Action Task Force grey list. What does that mean? It means that Kenya has been found wanting, has been weighed and has been found wanting when it comes to having laws that address money laundering and terrorism financing, and also when it comes to the implementation of those laws. To give you an example from the report that was produced by the East and Southern Africa Anti-Money Laundering Group, considering where Kenya is located, considering the significance of Kenya in its economic size, the countries that surround it. Kenya, at the time of the mutual evaluation, I believe only had 3 terrorism financing investigations or cases ongoing, which doesn't make sense. Surely that should be considered a priority, and therefore there should be more investigations in that regard. That is but to name one example. So because of that, AML CFT has gained prominence. And the question that we have this afternoon is how or why should we integrate issues of AML CFT into the legal curriculum, and how that can be translated into practice, particularly into having the ethical wherewithal to know when clients bring us issues that are bordering on AML CFT, or where we are not certain as to whether we will end up allowing ourselves being used as conduits for wash. So I will pose my first question to my brother James. Why do you think it's critical to integrate AML safety and financial integrity and ethics into the legal education today?
Good afternoon, everyone. Thank you, Madam Attorney, for that question. Before I answer that question, you've talked about the FATF, Financial Action Task Force, and the grey list, and you said Kenya, we didn't do too well, which is true. One of the factors that got Kenya into the grey list, this is the second time that Kenya is in the grey list, is aspects on the legal profession. The first time we got on the grey list in 2009, one of the issues of concern was that the legal profession was not implementing measures for combating money laundering and terrorism financing. That was a concern also, as Madam Attorney has indicated in our report, which was adopted in September 2022. So the role that the legal profession plays or doesn't play has a direct impact on the country, the economy, and all other areas. But that's a question for another day. So going back to the question of why we think, why I feel it's important that we integrate aspects of anti-money laundering into the study of the legal profession is one, just starting with that, the impact of why what we do or what we don't do as a legal profession. But more importantly, the subjects of combating money laundering, combating terrorism financing, these are new emerging areas. If you talked about combating money laundering probably 20, 30 years ago, it was maybe a more concern for the developed countries. Now it's a concern for all of us. The new and emerging areas, the areas which we are required to implement as a part of the global community. So it's important then for us then to integrate this into our study in the legal profession. We could do this in a number of ways. We could bring in the study. I know currently in a number of jurisdictions, anti-money laundering is studied as a postgraduate subject. There are a number of people who have taken postgraduate courses in anti-money laundering. So they have a postgraduate degree in anti-money laundering or combat finance of terrorism. But we need to bring this not as a specialized area. For those who choose to specialize, yes, they can. But we need to bring it to the general understanding of more lawyers. So we need to bring, in my view, this as a study which should be undertaken as part of the bar exam. When one is joining the bar, we should study this at the Kenya School of Law. And probably as more as implementation, because implementation of anti-money laundering, combating financial terrorism measures globally is still, okay, it is young in some areas, developed in other areas, but the literature out there is growing by the day. As we implement these measures, as literature develops out there, as we have more cases being decided, then we can also study this more at the undergraduate level. But for now, in my view, I think if we start doing it at the bar exam or the final year exam would be good, because I don't know whether we have enough material at undergrad to study it. I'm that man. But more importantly, why do I say that it's important that we study this? So if you'll allow me, I would want to spend a bit more time into the why. Why is this an important subject that we need to integrate into our curriculum as lawyers at whatever stage? One, the principles of anti-money laundering, combating financing of terrorism. As I said, these are relatively new areas. I've been interacting with a number of lawyers in the profession because we are trying to make sure that this subject is understood. One of the areas or reasons why we faced resistance about implementing these measures in the legal profession is lack of awareness. So we need to increase this awareness, both for lawyers who are in practice and even much earlier. So understanding what combating money laundering is, understanding what, just basically, what is money laundering? We do a number of sensitizations, but we now need to understand it more from the legal perspective, because as lawyers, we are said to know everything, and we should know everything. So we need to know the basic, the fundamentals of what is money laundering, what is terrorism financing, what is proliferation financing, and why are these subjects important to us. So this we need to then ingrain into our curricula at the earliest opportunity. And as I said, if we could have it at the stage where we are doing the bar exam, that would be a good thing, because at that time, the students have a fairly good knowledge of financial crime. Money laundering is about financial crime. How do we combat financial crime? At the undergraduate study, of course, the academia will be better placed to study this. But I believe at that time they have a better understanding of what is financial crime and would be able to understand. The other important reason why we need to integrate anti-money laundering is because the legal profession is one of the sectors that has been singled out for potential abuse by money launderers. When you look at the category of who can be used for money laundering purposes, we have two broad categories. We have financial institutions, and we have designated non-financial business and professions. They have been designated by the FATF, Financial Action Task Force, because of the vulnerabilities that they pose. Lawyers, as legal professions, can be used as professional enablers. Lawyers and accountants, and also trust and company service providers. Because of the nature of the work that we do, we can be used. So it's very important that we are then aware and sensitized as to why we must understand money laundering, so that when you're getting into practice, when you're getting into the legal profession in whatever capacity, then we have that better understanding of the potential for abuse, because we as lawyers can and have been used unknowingly to launder funds. But of course, there are also lawyers who have deliberately chosen to assist others to launder funds. If you look at the aspect of criminalization of money laundering, which is another reason which I'm going to come in later, one can be charged with the offense of money laundering because of helping structure a transaction, helping structure an activity. As lawyers, that's what we do. We give advice to our clients. We help our clients with face various legal problems. Even in the field of conveyancing or commercial law, you help structure those activities. But if that structuring is being done in a way to assist your customer to then hide the funds, then you as the lawyer are also liable to be charged as a principal participant in the offense of money laundering. So it's important for us then to know this. So that when you're there sitting in your practice, when you're there in your office, handling those transactions, we are then aware about this. The other important thing why I believe we need to understand this, it's all about the risk-based approach. In implementing anti-money laundering measures, it's about the risks. Where do the highest risks lie? When you look at the national risk assessment for combating money laundering and terrorism financing in the country, the legal profession has been ranked as amongst the sectors which bears the highest risk for money laundering and terrorism financing purposes. This was in 2021 when we did the national risk assessment, when we updated it in 2023, when we did the terrorism financing risk assessment, and all the sectoral risk assessments that have been done by the various sectors, in the financial sector and other sectors. The legal profession has emerged as the one of the sectors which is highest risk for money laundering. And that should concern us as legal professionals. And that is why we need to then see how do we then mainstream this, this knowledge of combating money laundering into our young lawyers at the earliest opportunity so that they can be aware about the risks that they face in the profession and why, in as much as we say in the morning, the legal profession is good, but as a professional, we can be subject to those risks. Also, another reason why I think it's important is because we have to understand how money laundering works. One of the ways to combat money laundering is about suspicious transaction reporting. We report, one of the ways to fight financial crime is to report suspicious transactions. Now, when the bill was being debated, the Proceeds of Crime and Anti-Money Laundering Act, one of the biggest things that the parliamentarians were asking, why should we criminalize suspicious transaction reporting? And it's important for us to understand why. Why do you want to jail people on the basis of suspicion? One of the strongest ways to fight financial crime is by having those reports, suspicious transaction reports and activity reports reported so that they can be looked at by the competent persons. And that is the whole framework of how this is designed. For us to be able to find the people who are engaged, we need to find out about this. So this brings out the issues about the constitutionalism about this, about privileges, rights and everything, about knowing about the issues of tipping off. So there's a whole safeguard of why that mechanism has to be safeguarded, because you're dealing with suspicion. And when you're dealing with suspicion, then you have to handle that information so that you do not breach the rights of other persons. So all this, it's very important for us then to be able to know at an early age. Criminalization and confiscation. When you look at criminalization of money laundering, the way it is, if you go to the Proceeds of Crime Act in Section 3 and 4, the way money laundering has been criminalized as an offense. Of course, there's the aspect of knowledge, need to know everything, but also I also said there's the aspect about participation. So when you assist another person, knowingly or unknowingly, you can find yourself then being charged money laundering. So as one of the new emerging crimes, terrorism financing, money laundering, proliferation financing, it's important then for us to be able to bring this and mainstream this into our curricula at an early age. I can see Madam Atwini is getting uncomfortable with time, so let me just pick out 2 or 3 other key areas which are important. I think also for ethics purposes, in terms of ethics, we need to then look at, when we study ethics at the School of Law, but we need to know about legal privilege. When it comes to combating money laundering, you find that the rights, legal privilege is safeguarded, but the rights to secrecy are overridden. And it's a very thin line. One of the biggest fights that we had with the legal profession was on the aspect of legal privilege, until we had to come up with amendments in 2022 to specifically safeguard already provisions in the law, but to ring-fence the issue of legal privilege. So it's very important that then we understand how does this then work. When James walks into your office with a briefcase of 50 million shillings, you're looking at, transacting, when you calculate your fees, that can translate to good fees. But where will that leave you? The aspect of international cooperation is very important. Also in aspects of mutual legal assistance, extradition, but also in investigations, because if you have to investigate money laundering, you have to know how to relate with the other agencies, both formally or informally. So these are very important aspects. Targeted financial sanctions is one of the areas where it's very important, because for targeted financial sanctions, there are people who have been designated by the United Nations Security Council, they've been identified and have been designated for and implicated for being involved in aspects of terrorism and terrorism financing. When you look at our laws, they're saying you cannot prosecute someone or convict someone without them being heard. Yet, the UN Security Council resolutions are saying you have to take action against that person without giving them an opportunity to be heard ex parte. So when you look at that, the conflict of laws, the issues of, so these are very important things why we need to understand. Lastly, the areas of emerging technology. In the morning we talked about artificial intelligence, we talked about virtual asset service providers and all that. VASP was not an area of concern for money laundering 3-4 years down the line. It was something which was of interest, but now it's mandatory. We have to put in place measures to combat that. So one of the reasons why we have even, as a country, enacted the Virtual Asset Service Providers Bill is because it's one of the things which was lacking in our legal framework to combat money laundering. So we need to have all this. And lastly, before Tony takes the mic, in implementing these measures, you will see that the measures for combating money laundering, they're not of the United, they're made by the Financial Action Task Force, of course drawn upon UN conventions. But as a country and all the countries in the world, the FATF is not a UN body, but yet we're required to implement those measures. And failure to implement them has consequences. So we need to understand the moral suasion as jurisdictions that comes with all this, which you can include in our legal curricula. Thank you. I'll leave it at that for now.
Thank you. The way you have articulated it makes me wish I could go back to law school and maybe do a module to get the proper theory, and maybe I'll do my job. But moving on, if I could ask Mr. Tu to now look at, considering what has been presented by Mr. Manyonge, what do you think how law schools can incorporate the partnerships? How can we draw on the partnerships of universities, financial institutions, law enforcement agencies to strengthen AML, CFT education? What can be done since you are in enforcement?
Thank you for that question. As you have all heard, my name is David Tor. Of course, some people say Tu, whichever it's okay. Well, Mr. Manyonge has elaborated on the issues of money laundering, but I need to start to say that the society has really evolved. So many things have changed. There is a paradigm shift. The criminal of today is so sophisticated. It is not the criminal of the yesteryears who used to take a gun and rob a bank. If you are a lawyer, I don't think you can recall any time you have been called or your client has been called to go and do an identification parade. And that tells you things have moved very fast. And things have come, other crimes have come like the anti-money laundering. Ethics and Anti-Corruption Commission is a lead agency in the fight against corruption. And we do rely on the suspicious transactions reports from the Financial Reporting Center where Mr. Manyonge is working. And in the course of our investigations, we come across lawyers or legal professions who have unknowingly participated in money laundering. Unknowingly participated in money laundering. And this is because they are not exposed to identifying red flags in money laundering. And so it is so important that the Council for Legal Education collaborate with oversight agencies, the law enforcement agencies, so as to have a deeper understanding on the ongoings in crime within the society and be able to inculcate or to be able to embed some of the issues that the law enforcement agencies are always encountering in the fight against crime, to embed in their curriculum, so as to move away from the criminal law. I saw Professor Sianya, he demonstrated the kind of topics that are in school. But I believe that, well, I have not been at the Kenya School of Law for some time, and neither have I been back to the university to understand what they are, whether it is theory or it is practice. So there should be much of practice. Lawyers should be able to understand what really happens in the practice world. We used to talk of lifting of the veil under the Companies Act, but other things have come. In the law enforcement arena, you find that even if you lift the corporate veil, you can only know who are the directors. But now we have beneficial ownership, where even those who are directors are just a medium of, it's a conduit to pass the funds that are being acquired through money laundering. You find that those who are enjoying the benefits are not anywhere near the company. They are getting the funds at arm's length. So it is important that the legal profession is equipped with the knowledge and skill to be able to identify those things like beneficial owners. They be able to identify associations of movement of funds, how money is layered, how money is disguised by clients. More often, the lawyers in the private practice are happy to receive a client who brings you business. But you may not know that person has stolen the money from either a public institution or from another private body, and it always involves a colossal sum of money. So if you are well versed with the way money is laundered, you can be able to identify the red flags, and this can be done by Council for Legal Education in working together with oversight agencies, the law enforcement agencies, and the providers of legal education, the universities and the Kenya School of Law, so that they are able to tune the kind of legal education that is being offered to the students to be able to understand what is going on in the society and to be able to respond to the modern challenges. Currently, in the fighting against corruption, there are issues of cryptocurrency or virtual assets, where the corrupt people have been able to disguise their funds which they have gotten in virtual assets. And these are things to be brought forth in the curriculum of our respective institutions. The jurisprudence has also changed, and so it is important for even the Council for Legal Education to determine what kind of textbooks or to use, because as a practitioner in the law enforcement field, you still find a case when you file in court, the lawyer on the other side still talks of the burden of proof is on the commission to prove. But let me tell you that the burden of proof in terms of an explained wealth, which has been acquired through money laundering, the burden shifts to the person who has the money or to the person who has the property. And so it is important that all these transformations are brought to the knowledge of those of those who have been taught to practice either in the private or public. Let me talk a bit about our Constitution. Our Constitution has given a lot of prominence on Leadership and Integrity Act, but the kind of I don't know the kind of the integrity or ethics that is being focused on majorly in our legal education is the professional ethics, not the bigger picture. But our constitution has brought in the issues of leadership and integrity, which we should so much, the Council for Legal Education should see a way of embedding issues of integrity in the curriculum. Make it as a big topic. I didn't see it in the curriculum that was shown here. I just saw professional ethics. Professional ethics may be slightly confined to the line of the profession that the person is taking, but not the whole picture of the integrity. And with also the coming of the Constitution, there are quite a number of attorneys and legal counsels in counties. And these persons are supposed to advise the county governments in all areas. The county attorney is the principal legal advisor of the county government. And they are supposed to advise on issues of procurement. So in as much as we talk of commercial law, we talk of issues of evidence, conflict of interest, we should be able to see topics on commercial law or on procurement being taught to lawyers, issues of finance, not the basic issues of just understanding the balance sheets. They should be able to understand the ethics in finance, the ethics in procurement, because these are people who are supposed to advise the public institutions in the areas they are working. So I wish to end at that and say that there is need for more collaboration with the oversight, law enforcement, and the providers of legal education, so as to be able to come up with a curriculum that is very responsive to the current needs of the society. Thank you.
Thank you very much for that. In the interest of time, the questions that I had for the two presenters, I'm sure they'll cover also as part of their presentation. I think the question for Diana would be how law schools can incorporate training on technology and AI tools for financial crime detection, which I think is in line with what you're going to present. And then for Eric as well, if you could let us know how we can instill a culture of financial integrity and ethical responsibility in the future professional, which I think also touches on the presentation that you're going to make. So perhaps allow me to now allow the two presenters to present in the interest of time. And I think the rest of the panel will move to our seats so that the presentation can be beamed. Diana, you have 10 minutes.
Hi, good afternoon. So I'll just proceed directly into my paper. I will be brief. I sense a cognitive overload in the room. So just give me 7 to 10 minutes of your time for me to summarize my paper. You will read the full extent of it once it's published. So in my research, I deal with the pedagogy of anti-money laundering within the LLB curriculum. Why is it important that we look at the manner in which we teach money laundering at LLB level? It's because LLB graduates produce the larger workforce of those in the AML sector. LLB graduates are the ones who go into corporate, they're the ones who go into governance structures as investigation officers. They also do so as AML investigation officers, as risk officers, and so on. And for this reason, if no other, it is important for us to make sure that the graduates we prepare for the market are able to meet the demands of the market, the current demands of the market, in terms of the skills and competencies that they carry with them into the job market. So we, are faced with an age whereby we need to move away from theoretical-based teaching for anti-money laundering, which has been the case. In a separate research where we got to analyze different curriculums in select law schools in Kenya and South Africa, we were able to see that money laundering is taught as part of a law of economic crimes. That's what happens in a larger part of the faculties of law. And this law of economic crimes is, in most cases, a fourth-year course, and it is an elective chosen by a few students. That is fine if the students who are interested in getting into that particular field get to choose the course. However, we now get to look at the learning outcomes, and that is where the problem is, because in the manner in which it's taught, it's such that it's largely theoretical. Students get to understand the legal frameworks, they get to read the national legal frameworks that apply. The POCAMLA, they get to look at how the EACC gets to conduct its investigations, how the ARA gets to undertake asset recovery and so on. But they do not get to acquire the practical competencies that they need as they get into the field. The field is quite unforgiving because it requires that a risk officer or an investigation officer who has an LLB should know how to undertake data analysis, should be competent in being able to handle and operate softwares, Power BI, Alteryx. I saw the PwC this year in the recruitment of graduate trainees requesting that LLB graduates should be competent in using Alteryx. That means that you now have to go make yourself competent in a software and then come back and make the application. It's only fair that as we teach money laundering, as we teach anti-money laundering, forgive me for the instances when I have said money laundering instead of AML. But it is important that as we teach AML, we make sure that the students are equipped with the practical competencies that are necessary for them to go into the field and be able to deliver. And you'll find that when we are talking of curriculum development, it means that the learning outcomes should also be in tandem with, they should be in tandem with the FATF recommendations. So such that when we're talking of practical competencies, is this student should be able to be competent in undertaking a KYC verification. That is under the customer and client due diligence, which is recommendation 10 of the FATF. They should also be able to undertake a risk-based investigation, a risk assessment, and that is part of the FATF recommendations in recommendation 1 of it. They should also be able to do the STRs, which were mentioned by my senior colleagues just before I presented. And this is also part of the recommendation 20 of the FATF recommendations, such that as we teach students at undergraduate level, are they in a position to handle common AML investigation tools? Do they have a capacity to undertake a risk-based assessment? That is the only way that we can make sure that we are preparing a competent workforce and not just an understanding of the legal framework. It is important, an understanding of the legal framework is important, but it is now important for us to incorporate practical competencies for the LLB graduate as they move into the workforce. I also, in my paper, look briefly at what artificial intelligence entails, but for this particular part, perhaps I'll just summarize the fact that artificial intelligence mimics human intelligence, and technology experts foresee a future whereby we will have machines that supersede human intelligence, and perhaps we should prepare for that as well. I do not know how we will operate as professionals in a world whereby AI supersedes human intelligence. But as at yet, in 2025, AI does not supersede human intelligence. It mimics human intelligence. And that is why, in some instances, AI does make mistakes, which is commonly referred to as the AI hallucinations. But we commonly have the traditional AI, and we also have the generative AI. The traditional AI performs specific tasks based on the commands that are given to it, and it can be able to do face-based screening, KYC verification. Then we have generative AI, which has managed to spark a lot of debate within the academic field because of the fact that it can produce content. So generative AI is content-producing AI. which gets to produce texts, audios, images, and so on. And we have generative AI models that are used in AML, such as Symphony AI. But of course, in the academic field, there's a huge controversy of ChatGPT. But it is no longer a concern for those of us who get to mark scripts quite often and tests. You can tell a student who has generated their answer from AI. If you mark on a daily basis, it will take you quite a short time to realize that they've done that. So the discussion is not about ChatGPT. The discussion is about preparing students to be able to use generative AI models for investigations as we teach them AML in school. So then we get to look at AI now as an essential tool in incorporating practical AML competencies. Remember that there are very many strategies in being able to make sure that a graduate is competent in AML. It is not just AI. We have data analysis, which is not entirely AI. We have them being able to understand evidence that's required, as was indicated by the former presenter, for them to be able to understand the investigations and the evidence handling process when it comes to AML. But AI is one of the ways in which students can be equipped as they move into the field, because it allows them to go to their respective corporate entities or administrative entities and be able to automate tasks which they don't ought to do manually. And this can really be assisted by the use of AI models as we teach. Then finally, and in the interest of time, we get to look at the main question, which is the role of the Council of Legal Education in encouraging the use of AI. What can Council do to make sure that AML practical competencies are included at the LLB level? There are a number of ways, but I will discuss curriculum reform and standard setting. So it is possible by virtue of Section 8 of the Legal Education Act, which empowers the CLE to regulate legal education. So by virtue of that, they can be able to require curriculum reform when it comes to economic crime, such that the learning outcomes of economic crime get to include practical competencies for AML and other economic crimes, as it will deem fit. But what is important is for them to propose curriculum reform, which is necessary in this particular age. Secondly is accreditation requirements, such that they get to make AI-supported teaching mandatory, such that students are now prepared for the field by being acquainted with using different AI tools. And capacity building for faculty members. It will turn out that a number of us, I also undertake consistent training, because you find there's a software that I need to learn today. Tomorrow there's a new one that you need to acquaint yourself with. So for faculty members to be trained on how to teach AI to students, how to teach the use of AI softwares to students, that would equip the teachers so that they are able to teach better. Of course, this is not as simple as is indicated here. You will find that different faculties, different budgets. Some faculties, no budget at all. And so AI tools, AI softwares do not come free. At times they do, but when you want to teach competent students, you need at times, you don't need at times, you need funding. You need funding allocation for you to be able to, have the facilities necessary to be able to inculcate the practical competencies to students. So even as CLE creates regulations, even as CLE creates standards, it is important for them to make sure that the regulations and standards are applicable and practical to all faculties in as much as they find possible. Otherwise, the regulations will end up being paper tiger, such that we have regulations for the inclusion of AI in teaching, but faculties with no budget to incorporate the teaching of AI competencies to students. There are challenges at faculty level which CLE also ought to be aware of, a number which I have discussed already. The challenges include limited digital infrastructure in faculties of law, a skills gap which can be addressed through training, And then curriculum misalignment, of which I have already indicated that the CLE can recommend curriculum reforms towards the inclusion of practical-based competency teaching for AML. And then ethical and bias concerns, which ought to be taught to students. So even as economic crime, even as AML is taught as a course to fourth years, it is important to teach technology and law in the first years, and I propose that it should not be optional. It should be mandatory that every student gets to be competent in how they handle technology as they move into a world that is largely driven by technology. To conclude my presentation, ladies and gentlemen, when we talk of AI, it seeks to enhance the efficiency of law students as they move into a dynamic and an evolving world. However, AI does not replace legal teaching. AI does not replace our work as lawyers. We remain lawyers. It's just that we are lawyers who are competent in how we handle technology. We are lawyers who are competent with working with AI-based tools, and we are equipped enough to be able to resolve the global challenges that we currently face in AML. Thank you very much.
Good afternoon, ladies and gentlemen. Good afternoon. My name is Eric Kibet. I'm the Dean of ZTech Law School. And that is the latest entrant in the field of legal education at LLB level. In the next few minutes, I would like us to talk about a research paper that I am still putting together, and hopefully in the end I can get thoughts from you, feedback by way of improving what I am developing. I thank CLE for bringing us together in this very important gathering, and hopefully what we discuss here will go into shaping the future of legal education, because that is our responsibility as players in legal education. My paper is called Rethinking Legal Education in Kenya: Skills, Values, Skills, and Relevance. And this work is divided into 4 sections, beginning with introduction, which speaks about what the entire paper is about, and then legal education in Kenya, past and the present, which is a historical overview, because we've made a long journey over the last 6 decades or so, as far as developments in legal education is concerned. So I discussed that in that subtitle or heading there. And then third, changes in legal education environment, which necessitate a need for new skills, new consciousness, and new values. And I acknowledge what the people who've spoken before me have discussed, and many of their thoughts resonate with what I present in my paper. And then the 4th heading or subheading is recommendations, charting the future of legal education. So overall, I discussed that historical context of developments of legal education. And the central argument is that the present framework as we have it Whereas there are good things to say about it, and there are many things that are working, I argue that for various reasons, it is inadequate in preparing future lawyers. It concludes by making a number of recommendations as far as reform in content, values, and skills is concerned. So looking at the first subheading, which is legal education in Kenya, the past and the present, a historical overview. One of the things I observe is that in Kenya, for years now, we have a situation that is liberalized but regulated. Because if you recall the discussion by Dr. Wambua, he spoke about different aspects and approaches to regulation. And our legal education context is liberalized, yes, liberalized to the extent that as many players as can come on board are allowed to come, provided they can meet certain standards and conditions set in law and enforced by the Council of Legal Education. That might exempt ATP for a while now, but as many of you will know, that too is set to change in the coming months, given the fact of developments that are ongoing. So that legal education from diploma, certificate, LLB, ATP are regulated. And if you look at the regulations also, that extends to LLM and PhD, although for these two, there are a bit of controversies here and there that many of you may have observed. So I observe that there is generally no consensus about a number of things that are critical to legal education generally. Number one is with respect to LLB and its liberalization. For over 30 years now, we've had more than one player in Kenya as far as provision of LLB is concerned. And as we speak today, we have 20. This was mentioned to us in the morning, and the numbers are growing. And yet, we seem to be surprised every time new players come. And many of you are aware about ongoing discussions about the number of law schools that we have in Kenya. That suggests historical biases, and perhaps even the fact that maybe we've not accepted that that field, just like other fields in education, have been liberalized. But secondly, is the question of ATP and liberalization vis-a-vis devolution. I use the term liberalization to mean invitation or licensing of other players to participate in offering ATP, which the proposed regulations and the decision of the Court of Appeal in Otinga decision is driving at. And it does appear again that as far as that is concerned, we don't seem to have a consensus about which is the right direction to go. And I attempt to explore that a bit, obviously without an answer one way or the other. And devolution as the other approach. And devolution here is a parallel of what we learned in the morning about the situation in Uganda with LDC, Law Development Center, where for some years now, LDC has been able to open campuses in other places in Uganda, which then in our context would be devolution as opposed to liberalization. And I use the word liberalization then to mean, strictly speaking, invitation or licensing of other players as far as ATP is concerned. And then the third aspect that is important to legal education, which again we don't seem to have consensus about, is the issue of academic progression and recognition of prior learning. For a while now, Kenya has tended to move in the direction of recognition of prior learning. And there are a lot of things to say about these, including academic progression, as far as issues of justice and justice in education is concerned. But as many of us will know, traditionally, admission to Kenya School of Law, which means to the bar, has been restricted to those who have a minimum of C+, mean grade at KCSE or equivalent, and then B in English, and sometime not very long ago also, or Kiswahili, English or Kiswahili, a minimum of a B. And this itself has, of course, shut out so many people. I'm aware, however, that the Legal Education Appeals Tribunal has made a number of decisions to uphold progression. But as a country, we don't seem to have come to a consensus about whether we want academic progression or we don't. And for what reasons do we take one position or the other? So I then move to talk about changes in the legal education environment, which then calls for new skills, new consciousness, and new values. Now, if you compare, and coming back to the aspect of the thought of liberalization vis-a-vis devolution, and speaking about liberalization of ATP, there could be some useful lessons to learn from other professionals. And an example that I have in mind that I can give you is the training of nurses in Kenya, for example, where the Nursing Council of Kenya participates in accreditation of institutions, and then in the end administers exams before one is admitted to practice nursing. Of course, what lacks as far as that is concerned, that example is concerned, is that there is no common place where all graduates in nursing go to be trained so that then they can sit the Nursing Council examinations. But there are also a number of jurisdictions which we can draw lessons from, and I will be exploring a number of those in my work. But it is important for me to say that the liberalization of ATP as proposed in the Court of Appeal decision of Odinga, as well as in the proposed regulations under the Legal Education Act, will be a historical shift. Those of you who followed history will know that from the time when we started training advocates in Kenya, Kenya School of Law has played a significant role, and most recently has been the only organization that trains in ATP. So this, in essence, will be a historical shift from what we have known up to now. And given the fact that it is a significant and a historical shift that most obviously will not be reversible in the years to come, it is important to then think about it a bit more carefully, and to think about the challenges and opportunities that it presents, because indeed there are challenges that come with it, and most certainly there will be opportunities that come with it, and we have to explore those and be informed accordingly. But one thing will be clear, that in all this, the Council of Legal Education will become a uniting factor. Uniting factor because it then means ATP will have many players. And because ATP will have many players, Kenya School of Law will no longer be a uniting factor, because that will be an area where many players participate. So that then the uniting factor that we will be left with will be Council of Legal Education, and that necessarily means it will be called upon to perhaps do more as far as ensuring standards in legal education, which translates into standards in the legal profession, is concerned, and I explore those thoughts in my work. For some years now, since 2012, when the current Legal Education Act was enacted, provision of training for ATP was effectively separated from the licensing function. But I have come across a few arguments and a few people who think that it is also perhaps necessary to delink regulation from examination roles. What merits can we draw from these discussions? In other words, to have a situation where now you have a completely independent examiner as far as ATP is concerned, quite separate from regulation of legal education, because what we have at the moment is that the examiner at ATP is also regulator of institutions, including ATP players. And some people think there is need to look at that kind of an arrangement, and I hope we can have more discussions and see which way to go. But as we do that, I am encouraged that up to now, we have had significant developments, and Rome was not built in a day. Development, including in law, is always an incremental process. But these changes will most certainly have an implication on Kenya's School of Law, because having competitors will essentially affect it one way or another, and that is important to bear in mind. Now, the other subheading in my work, which I want to take a few minutes and talk about, is this one on competency-based education and training, CBET, and the future of legal education. As you will know, Kenya is currently implementing a new system of education. It is called competency-based education, competency-based education and training, CBET. The T, of course, there to take care of aspects of tertiary education. And so how does this affect legal education? Most certainly, our legal education will have to adjust so as then to take into account and conform to this new legal education, education system that the country is currently implementing. LLB and other legal education programs were designed against the background of the 844 system. And now that we have a new system, what do we need to change? What do we need to adjust in order to be compliant? That is an important discussion that we need to have going forward. Now, CBET has 3 career pathways, so that when pupils finish senior school, you're either in the pathway of social sciences or arts and sport or STEM. STEM there is sciences, technology, engineering, and math. So that does appear to be a straitjacket of sorts. The beauty of KCSE, as we have had it up to now in 844, is that if you thought you're a science person, and then later on your results tell you otherwise, then you can choose to go wherever your results dictate you as far as university and tertiary education generally is concerned. But now with pathways in senior school, what will this be in terms of implications for entry requirements for LLB in particular, and also the other courses as far as law is concerned? And there is quite a bit of stuff to talk about there, including entry requirements. This is not too far off to talk about, because when are CBC graduates expected in campus for LLB and other courses? What's the year? 2029, which means by then we have this year, next year, and the other one to be able to talk about this and fix it before they arrive. Now, CBET has a number of national education goals. In other words, the goals that in running through our education system, we hope as a society and a country to achieve through education. And The big question here would be, what is legal education doing to ensure that these national education goals are achieved, particularly those that I have mentioned there? And then there is a question of 26333, and it means the degree courses, possibly including law, will have to be cut down to 3. That has implications in terms of LLB is designed, the number of courses, and of course, it has implications about whether we need to adjust ATP to take into account the changes that will have happened before. The other point that is important here is with respect to happenings that are going on. We live in an information age. We have Gen Zs and Gen Alphas and others are coming, and we have technological advances. What are we doing in order to ensure that we also take into account these changes that are happening as far as legal education is concerned? And the key that I can emphasize there is adaptability. There is a limit to which we can go as far as adding new courses because new areas have emerged. But what is important to do is to think about how can legal education produce graduates that are adaptable so that irrespective of the changes that happen in the future, they will be compliant, they will have an attitude to learn and be able to operate in new contexts. And then, importantly, and this I just mentioned in passing because I have to close, is the incessant deficit in values in our society amidst global illicit financial flows. And this is a question that the moderator asked me to speak to. Of course, as lawyers, we know that we have so many laws that deal with corruption, ethics, and things like that, suggesting, of course, that we don't like corruption and we want to change. But the paradox is, it seems like the more laws we have, the deeper the sleaze. And the big question is, what can we do differently in order to instill ethics amongst our graduates as they go through legal education? And I have a number of thoughts to share under that heading. And so, at minimum, is that in the future, law curricula should respond by taking into account emerging areas of law. Secondly, to think about digital skills and enhance that, imparting creativity, creative thinking, which has been traditional focus, but also entrepreneurship, because majority of the lawyers we produce will have to create their own opportunities. And then, of course, delivered to fit today's and tomorrow's learner, the Gen Z, Gen Alpha, and the others. And a lot of studies have been done about the characteristics of these learners and how education systems need to adjust to accommodate them. And then prepare lawyers for contemporary practice while preparing them also for the future of jobs and the future of practice. How will 50 years from today look like? We don't know, but what we can do is to emphasize on adaptability. And then the last two is to incorporate core areas of law while fostering adaptability, as I said. But as we do this, to also see that we can have a healthy balance, especially considering that we might be affected in terms of how much time we have to offer LLB under CBET. And then find ways of infusing ethics and values so that hopefully we can have honesty in the legal practice and hopefully an honest society. I'll stop there and I thank you.
SCCA, thank you to the panel and to the presenters. If we could give another round of applause, please. I think I hand it over to Jennifer for the next steps in the program.
Thank you very much to the presenters. We'll now move to the breakout sessions. So I'll guide you on how we'll be doing this very quickly. If you have any follow-up Q&A, I think we can pack the questions and do that in the morning tomorrow during the summary of the proceedings of today. So we have 2 breakout sessions from your program on page 7. Breakout session 1 is on the global trends on reshaping legal training, AI, digitalization, and governance ethics. So we'll be looking at some of the things that have already been intimated by the panelists that have come before. We will have Mr. Wycliffe Sewe, who's a regional representative for A&D Forensics in East Africa. We've worked with him extensively, and he provides some training, specialized training for that matter, to a lot of our law enforcement agencies. We have Mr. Moses Munoko from the Legal Education Tribunal. We have Dr. Caroline Maura, who will be presenting a paper on regulating the use of AI in Kenya's legal education sector. Mr. Nyaika Hilary, are you in the room? Who will be presenting on integrating artificial intelligence in legal education, and Mr. Jared Gekombe. This session will be moderated by Mr. Evans Ogada, an advocate of the High Court of Kenya. Evans is already in the room, and the session will be run in this room in the pavilion. So you have exactly 1 hour, after which you'll be free, Evans, you'll be free to close the session and invite the participants for tea, and then we'll meet tomorrow. Then we have breakout session 2. I invite members who are interested in this area to join myself and Florence downstairs in the tent. So in terms of the directions, you're going down just past the swimming pool on your right. You will pass the gym area. The tent has been set up in the tennis court. So everything is set for us there. I hope we will see some of you there, or a majority of you. It's going to be a very interesting session. We have Mr. Dennis Moroga from Moi University School of Law. We have the head of the Financial Intelligence Unit at DCI, Mr. James Githinji. We have Mr. Geoffrey Obiri representing the DPP. He's a senior assistant public prosecutor. We have the representative of Mr. Hezekiah Aseso, council member and AML convener within the society. And we have 2 paper presentations, one from Mr. Okello and Mr. Byron, who jointly wrote on enhancing integration of AML CFT frameworks in legal education, and Ms. Nagadia Hamida on bridging gaps in Kenya's undergraduate education. So this, again, will be moderated by Ms. Florence Shako, an advocate of the High Court of Kenya. Thank you, Florence, for moderating this for us as well. I will request that we also do strictly 1 hour so that we are done by 5 p.m. Then you invite, again, the participants within your breakout session for tea. Tea will be served the same place, but should there be any changes, I will move around to guide the participants as well. Please, we have, give you, I think, 5 minutes to settle down within the breakout session of your choice. For the participants in this room, the presenters for this room, you can start moving up, and then the rest, let's meet downstairs. Wishing you fruitful breakout session, and if we don't meet again, have a lovely evening, and see you tomorrow morning.
So, ladies and gentlemen, distinguished scholars, practitioners, and future leaders of the legal profession, welcome. Today we gather at a moment of profound transformation. The global landscape is being reshaped at unprecedented speed by three powerful forces, and this is artificial intelligence, digitalization, and the urgent demand for ethical governance. From courtrooms and adopting machine-assisted decision tools to law firms leveraging predictive analytics, governments digitizing entire justice systems, the practice of the law is no longer confined to statutes and casebook. It now intersects with data science, cybersecurity, algorithmic transparency, and digital rights. These shifts are not abstract. They demand a new kind of lawyer. Discussing global trends, reshaping legal training, AI, digitalization, and governance ethics invites us to interrogate how legal education must evolve. How do we prepare jurists for an era where AI drafts contracts, blockchain records property rights, and cross-border digital governance challenges traditional sovereignty? What new competencies, ethical reasoning, data literacy, interdisciplinary thinking must we embed in our training? And critically, how do we ensure that innovation enhances justice rather than eroding it? This conversation is not just timely, it is necessary. The choices we make today about legal training will shape the integrity, inclusivity, and legitimacy of our justice systems tomorrow. The panelists are here. Ladies and gentlemen, let us give them a warm round of applause. I come from the Moi era, and I'm still a Moi student. So this is how we are going to do it, wherever I'm on my feet. Let's do it better. Moja! Santi, those are standing instructions. We will be doing that till the end. So, panelists, Professor Odote is my boss. I have instructions from him. I have to execute this mandate within 1 hour. Say amen. Amen. So we are going to do it within 1 hour. Gigombe, you are my brother. I know you have a good paper, well written, statistics, na kila kitu, urembo yote. We will do it within 10 minutes, max. So when you see the lanky frame hovering around you, that's time to call it quits. Sindio? Asante. Do we have Mr. Sawe here? Mr. Sawe, opening remarks, precision, bullet point, 10 minutes max. Do we have Mr. Munoko? 10 minutes max. If you can do it in less, superb. Let's start with your opening remarks, and then we go to the panelists, okay? Thank you very much. Mr. Sawe?
Check. All right, thank you so much. Even as they try to fix this, as you've heard, my name is Wycliffe, and I'm actually a managing partner for A&D Forensics East Africa. And at A&D Forensics East Africa, our specialist is drawn towards virtual assets, where we normally do a lot of capacity buildings and trainings around virtual assets. We also do assist law enforcement when it comes to crimes touching on virtual assets, and also supporting the financial ecosystem when it comes to risks and compliance and the exposure to virtual assets. Of course, I have my team over there also as well, Flora and Adi and Rhoda. You'll get to interact with them even as time goes by. So I've been given 10 minutes, and I'll try as much as I can to make it 9.9, if that's okay. So I think with that being said and done, allow me to shoot straight to this key topic of virtual assets, which has been spoken since morning. So why is this conversation very much important, especially to the legal practitioners? We need to understand that virtual assets and digital finance are currently growing, especially within the financial ecosystem, as you are going to see. And of course, with virtual assets has really changed how financial transactions and crime and compliance basically works. And lawyers for today must basically be able to understand blockchain and virtual assets, their compliance expectations and the investigation approaches. And the courts that we currently have in place have also been experiencing or receiving increased cases which are related to cryptocurrency. Allow me to just take you towards what is currently happening globally so that you get to understand how this topic is massive and deep. We already have a global shift towards digital currencies. We have been seeing major players in the ecosystem. The banks, you can see most of the players, I believe you can be able to understand and know their names, the likes of Citibanks, HSBC. These are some of the global players within the financial ecosystem who have already started developing new products around virtual assets. Some of them are already developing coins around that ecosystem. So what does that mean in the, from the legal lens? It basically means with this type of clientele, they'll definitely need some of your services from the legal angle, and they'll expect you to basically be able to understand virtual assets. So these are some of the major banks who are basically participating within the virtual assets ecosystem. So a few weeks ago, we have already started seeing even some of the giants within the money remittance space already introducing some of the their tokens called stablecoin. We just saw Western Union the other week did a press release when they were announcing or releasing their USDT stablecoin, and this is basically being used for remittance purposes. We have already seen the giants, the Visa and MasterCards, already playing part within the virtual assets ecosystem. So it definitely shows how there is already a shift from traditional finance to the virtual assets ecosystem, especially from the major players. And of course, we have already started seeing some of most of these institutions demanding legal experts. And it's being said right now that especially for the legal team or legal practitioners, you really need to even have the blockchain technology knowledge, all right, which will basically help you to navigate through the virtual assets ecosystem. We are already even seeing some of the legal firms across the globe who have already started establishing dedicated virtual assets team, which will be handling cases which are more or less crypto focused. And these are some of the developments which are we are currently experiencing within the global ecosystem. With that being said and done, allow me just to take you through very fast the crypto adoption in sub-Saharan Africa. In the span of 1 year, that is from 2024 to 2025, we are seeing the sub-Saharan African alone received a total of 205 billion on-chain activity. And on-chain activity basically means crypto transactions which are basically happening, both sending and receiving within the sub-Saharan ecosystem. And this clearly indicates 52% increase from the previous year. And we can see the global illicit crypto activity in 2024, we are talking of a value of 51 billion, which basically means we have already started seeing some criminal element already within the virtual assets ecosystem. So with that being said and done, we are already seeing regionally, as we narrow down, Kenya being also named among the top 5 countries within the African ecosystem. And you can be able to see we are being ranked at number 3 when it comes to virtual asset adoption, which clearly indicates the uptake of cryptocurrencies within the Kenyan ecosystem. So globally, Kenya is being positioned at 28th position. I don't know how many countries we have within the globe, but Kenya basically being ranked at number 28 clearly tells you the uptake of cryptocurrencies activities within the Kenyan jurisdiction. I think with that being said and done, you can also be able to see from the crypto websites visited by Kenyans, you can see some of the virtual asset service providers. You can see last year alone from 2023 to 2024, we have over 5 million Kenyans who basically visited some of these platforms, one of them being led by Binance.com. I know maybe probably for the people who are currently in the room, you have heard about Binance quite over and over. These are some of the virtual asset service providers that we currently have within the ecosystem. If you look at the money being collected within the virtual ecosystem, Kenya alone, these are Kenyans connected wallet addresses, all right? And this is for only one particular asset, which is Bitcoin. And with the wallet addresses which are attributed back to the Kenyan jurisdiction, has an amount of over 279 million this is money which is only held by one particular asset. But within the virtual assets ecosystem, we definitely have quite a good number of assets. We saw also from some of the dailies how Kenya alone wired over 429 billion in stablecoins transactions. That clearly tells you how still the uptake of cryptocurrencies within the Kenyan jurisdiction is massive and huge when you look at the numbers which are currently being transacted within that particular ecosystem. So with that being said and done, of course, in criminology we normally say where there is value, where there is money, criminals will always gravitate towards that segment. And currently you're already seeing crime shifting from traditional crime to virtual assets enabled crime. And we saw the other day also from some of the news which are being released within the ecosystem, stablecoins as one of the cryptocurrencies which has turned out to be the favorite for criminals and illegal transactions. All right? And because of time, maybe probably I won't dive deep into this, but stablecoins is just a type of cryptocurrency. Just as the name has stated, being stable, maybe probably that makes it more a little bit inviting to cyber criminals whenever they're conducting illicit activities. And why do these cryptocurrencies especially become more appealing to the dark side of the bad guys? It's because of perceived anonymity. It basically, with some criminals, they usually think that whenever you're doing transactions within the virtual assets ecosystem, you cannot, somebody cannot be able to tell. But ideally that is perceived anonymity, but because whenever we are handling such kind of cases with a little bit of some expertise, we are always able to put the face behind the person doing the transaction. And of course, most of the transactions are borderless in nature. They touch several jurisdictions and the speed of transactions very fast. We normally talk about the critical window. Whenever we are doing trainings for law enforcement, we let them know the reason why they really need to act with a lot of urgencies, because with virtual assets, they normally operate within a particular critical window. Between 0 to 30 seconds, that is enough for a suspect to initiate a transfer within the virtual assets ecosystem. 30 seconds to 5 minutes, initial transfers usually happen. Between 30 minutes to 2 hours, we normally start experiencing multiple transfers, and after 2 hours, assets are usually landed within that ecosystem. And that is why whenever now we are developing regulations and updating our policies, we really need to take into consideration the critical window that we have within the virtual assets ecosystem. Key virtual assets risks, and which every professional expert practitioner needs to understand. Of course, with virtual assets, we have been seeing bad actors using a lot of it towards money laundering and terrorism financing. We have got fraud and investment scams. We have got sanctions and regulatory breaches. Those are some of the key illicit activity where virtual assets is highly consumed. And of course, we have also the stablecoin-driven risks. So with that being said and done, we are also seeing some of the virtual asset service providers who are giving us platforms where you can be able to transact without collecting your KYC details. So you can imagine if you have such kind of platforms within the ecosystem, then they will be more inviting to the bad guys. So we have already started seeing also some of these virtual asset service providers within the Kenyan ecosystem. The other day we saw the bankless Bitcoin installing their Bitcoin, and already we have also started seeing even the mamambogas. I don't know how many people here have got wallet addresses, but this is to tell you that whenever we talk about mamamboga initiatives, of course we are seeing virtual assets being consumed even to the grassroots level. We are seeing mamamboga, you can be able to purchase Uji Power using your Bitcoin. So that clearly tells you, if you look at Kenya, as I conclude, Kenya has been topping when it comes to the scam activities at 60%. This clearly shows you some of the illicit activities that happen within the virtual assets ecosystem. So especially with the legal team, what you really need to understand, of course with the FATF, which are some of the global institutions who have been coming up with the recommendations around the virtual asset space, it basically means with the legal team or the legal practitioners, you really need to understand the risk-based approach towards virtual assets, the KYC, customer due diligence, the travel rule obligations, and every other thing. So what are some of the roles for legal practitioners within the virtual assets ecosystem? Most of your work will be needed, especially for the crypto businesses, the virtual assets which I've named, drafting and reviewing virtual assets related contracts, supporting due diligence in virtual asset transactions, and of course guiding in matters of assets recovery and freezing involving virtual assets. And that's why, especially from the legal lens, you really need to start understanding what virtual assets are. And of course you need to understand the blockchain forensics bit. In blockchain forensics, we normally talk about tracing
transactions across wallets. You need to understand what that is all about, identifying red flag patterns and linking pseudonymous addresses to known entities. And that forms large part of whatever we normally do at A&D Forensics. I know with most of the cases that you have been handling, you normally come across some of the bank account details, which has details which maybe probably you can be able to interpret, but going forward you'll be receiving cases with wallet addresses which also represent account, which do not have names of people whom you maybe probably and you really need to have some little bit of expertise in order for you to be able to get to understand who exactly is controlling that wallet address. I think this is my last slide. This is just a sample of what a crypto account basically looks like. I know from normal banking transactions, we normally understand how it looks like, but this is one of the crypto transactions. You can be able to see from the method, I've marked it in red, transfer is easy to interpret, especially from the legal perspective. You just know one was transferring one asset to another asset, but now you can see how things are getting complicated from this angle. Another particular account is showing now the high level, the methods which some of these bad actors they normally use whenever they're conducting their transactions. And that is why from the legal point of view, you really need to understand how virtual assets work, and in order for you to be able to even support clients from that angle. Capacity building, that is something that have been touched and talked about from the previous presenter, so I won't spend much time on it. So the key recommendations, which we're basically talking about, especially updating of your core curriculum to accommodate emerging technologies or emerging global trends, joint training and capacity building initiatives to build technical competences, and of course partnering with emerging technology service providers like ourselves in order for us to assist you the process of the journey. I think with that being said and done, allow me to stop at that particular point. It was my time, Sir Wycliffe, and thank you so much until we meet again during our discussions. Asante.
Mr. Sawe has done 12.08. He had promised 9.9, but nonetheless, clap for him. This is where we lose instructions. Tulisema tunapiga makofi ya Moi. Moja. Thank you. Mr. Munoko. Good afternoon, sir.
Thank you. I'll do a very, very brief presentation about digitization and AI. As you know today, AI and digitization is the thing of the day. And from today, I think from some time ago onwards, that is what we are going to live with. And AI did not come to replace the brain, but AI came in place to complement the reasoning and the thinking of a man. So I'm going to deal with two things that probably AI and digitization has changed. And over time, there has been a metamorphosis of crimes. Crimes that used to be there in 1990s, 2005 are not the current crimes. So with the current crimes that have come with the digitization, are our students, which universities are producing, are they based to face and deal and bring solutions to those crimes? Or are they not fit to bring a solution for those crimes? One of the things that I want to bring to our attention is that currently we are dealing with digital evidence. Are we teaching our students about these issues? Because when we are talking about cryptocurrency and Bitcoin, one of the things that come in place is that when an investigator goes out and gets this criminal, there is digital traces that are going to be presented in court as evidence. There are three people that are going to be involved in this thing. Person number one, who is a lawyer, is a prosecutor. Person number two is a magistrate or a judge. Person number three is a defense lawyer. Then we have two different people that also play a crucial role. One person is the perpetrator, the accused person. The next person is the investigator. Most of the times we've been in court and you realize when an expert comes to testify and now you tell the defense lawyer, can you cross-examine him? He says, I have no question. Reason? He is not well versed with the digital evidence, not well versed with the cyber security that we are dealing with. So our children, our students that you are teaching now, you have to bring them to the current crimes that we are dealing with. When our friend Manyonge is dealing with anti-money laundering, waiting for money to hit my account, the criminals of today are so clever to an extent that they have changed the way they deal with money and converted it into Bitcoin and cryptocurrency, so that when you look for these people to get them, you are not likely to get this money on their account. And this money is the same money that is being used to fund terrorism, to aid terrorism, and they are the conduits of money laundering. So money laundering is actually also changing from the normal money laundering that we've been seeing commonly to the money laundering that is going to crypto. Because when you have money, now you're not going to deal with the cash. You are going to deal with it virtually. And when you deal with it virtually, when this case arises, how are we going to handle this case as the legal minds? So unless you prepare the students from the university to come and deal with this, the practicality of these issues on the ground, in courtroom, and in practice, we are not going to make it. Yesterday, I was reading about the DCI has launched training on blockchain and cryptocurrency on their officers. But now these people, the investigators are being trained. But now the prosecutors, people are going to be defense lawyers, people who are going to analyze this evidence and give judgment. Are they prepared? Are they knowledgeable in these fields? And those are the areas that we need to ask ourselves. Are our students able to handle these matters? As we prepare our children, the market that is going, sorry, not children, our students, as we prepare our students, the market that is going to come in future is going to look for a lawyer who is multifaceted. Soon they are not going to look for a lawyer as a separate person. They get somebody else to deal with technology. But if we have a lawyer who is both versed with matters to do with technology and the law, this person is going to have an added advantage on the market, unlike just a lawyer who is just getting out like a 1982 lawyer. Because currently, without being biased, if you get somebody who practiced in 1979, dealing with crimes of 1979, and somebody who has to deal with the crimes of 2025, they are totally two different crimes. We are also currently dealing with digital elections. Initially, we used to deal with paperwork. Now, in the process of rigging, and you are told to analyze, or you have, as an advocate, you have to cross-examine a digital auditor. Do you have the knowledge to cross-examine that person? Those are the questions that we need to be asking ourselves. When we produce these students to the world, are we producing them to deal with the solutions, to bring solutions to the issues, to the crimes that are outside there? Or what are we producing to deal with? We are dealing with AI, and AI is playing a very crucial role in criminal justice. For example, also when we talk about matters to do with forensic and the law, we need to ask ourselves, are we collaborating with institutions that are forensically enabled to ensure that our students can access this information? For example, the DCI has a forensic lab. Which university has collaborated with the DCI forensic lab to ensure that their criminal law students can go there and learn how document examination is done? Because we always meet these people in court. Are we collaborating with these institutions to ensure that we tap this knowledge from them so that our students are also benefiting from these laboratories. Medical students, they collaborate with hospitals so that they do their practicals there. But as legal practitioners, are we collaborating with some institutions which offer, we can say, complementing courses to law? Because law, we are called learned friends. We have several fields. We have medical fields, health law. Are we collaborating with people in medical fields to know how our students can deal with the issues to do with toxicology? These are the issues we are struggling with. So, as I finish, sorry. So, criminals currently are also trying to use AI to circumvent the law. They are trying to use AI to commit their crimes. But as a victim, how are we also going to ensure that they use AI to avoid fraud commission? So, a second. So my point here is, as institutions, as we produce these students to the world, let us ensure that we are producing them to the society to resolve a certain problem. We are producing them to a competitive world whereby we are not producing them for the market of Kenya, but our students can go to Singapore, can go to the US, can go to the European Union and become relevant, because what they are studying here is relevant globally. Thank you.
We can do that better for Mr. Monoko. Makofi. Thank you. Thank you very much. Now we go to the paper presentations, and I will start with my brother, Mr. Gekombe. We go way back. Mr. Gekombe works with the Law Society of Kenya. I will ask him to join us and give us his stellar presentation, which I know is always better researched, in 10 minutes. Thank you, sir.
Thank you, Senior Ogada. Good evening. Good evening, colleagues. My name is Gekombe. I'm going to make a brief presentation because of time on the use of AI in teaching and examination of students. So today I don't stand here as an expert in AI, but I stand here as a law teacher who has encountered AI. We examine students, we receive assignments on a regular basis, we mark student work. Over a period of the last 7 years I've been privileged to teach, I've seen a change in the submissions that we receive. And the change is that nowadays you fear giving a takeaway assignment because they will just upload everything on ChatGPT and then they'll send you what ChatGPT has generated. Some even forget to add their name to the assignment. So it's a reality that we face. And as a teacher, I've thought about this. I am also a student at the University of Pretoria. I have seen what my institution has done in terms of addressing this. So mine today is to speak to you, not about the threat of AI, but it is inevitability. And I talk about the urgent responsibility for us to rethink legal education in Kenya. As I've said, I'm making reference to the University of Pretoria institutional response to AI in higher education. It's one of the most comprehensive responses in the region. So what the institution has done is that it has developed a student guide and a lecturer's guide. And in those 3 guides, the institution is calling for responsive use of AI, transparent use of AI, And the call is that even when we are doing referencing, it allows for students to indicate to what extent they have used AI in drafting the assignment or in submitting their work. One of the things you will notice is that AI has exposed our traditional legal education, in the sense that, traditionally, education has relied on content-heavy, lecture-driven, memorizing, closed-book exams, guarded even with police officers, one-answer assignments with very little feedback. And we have had, unwritten scripts and all that. But over time, AI is able to do all that. AI can summarize a case, they can summarize authorities, AI can draft pleadings. If you give students an assignment and say, go and draft a plaint, they'll go and upload those facts on ChatGPT and the plaint is there. And there is no, you are not able to see the value or you are not able to separate the input of the student in the assignment. So there is need, and also, other things that AI is able to do, explaining complex concepts through examples and analogies. AI is able to generate multiple viewpoints for critical analysis. It's even able to simulate oral arguments. Okay, so what the University of Pretoria has done is that they have taken AI not as an enemy of education, but as a tool. And this tool is not to replace critical thinking, but it is to enhance critical thinking, and also human judgment and independent reasoning. So the point is, if you set a question, you're a teacher, you set a question, and AI is able to answer that question, then we need to rephrase that question. Because where we're headed to, students are able to sneak in gadgets into exams. I have found students with gadgets in exams. The current crop of students are very innovative. They have ways of dealing with technology. So they will smuggle phones in the exam rooms, they'll photograph the exam questions and upload them on ChatGPT. ChatGPT is able to generate answers to that question. And if it's a takeaway assignment, if it's an online exam where there's no one supervising, the student can be able to give you what ChatGPT has generated, and you are not able to get the student's input. This is a reality. If you are able to stop phones, that's not the solution, because we can't. The question is deeper. What kind of examination system collapses the moment a student has access to AI? So what we have, the university has done is not by stopping or prohibiting use is disclosed, AI use is integrated, it's critically evaluated, and AI use becomes part of the learning process. And this approach is far more intellectually honest than pretending that AI does not exist. So in terms of transforming assessment, there are three pillars. One is transparent AI integration, where the university requires students, when they're submitting assignments, to fill a declaration form. We are used to the plagiarism declaration form for assignments, but they have added another one. It's called the AI declaration form. So the student discloses whether they use AI and to what extent they use that, and that transparency discourages dishonest use, and it teaches students to evaluate AI critically. So mine is to call us to adopt this approach. The second pillar is designing assessments that AI alone cannot complete. So set questions that require personal reflection, questions that require oral defense, questions that are jurisdiction specific, county specific, and also have multi-stage drafting questions. And also you can have sessions where students can critique AI-generated versions. And also you can have real-life problem-solving questions. So in this model, students are able to identify the weaknesses and the errors of AI, including missing authorities and all that, and they're able to improve the draft and defend their final versions orally. The third is with regards to oral examinations and the in-person verification. So let us use oral examinations, live simulations, interview-style assessments, courtroom, moot court, practical assignments. For lecturers, the lecturer for the future, you need to start using AI. You are encouraged to use AI, to design lesson plans, to generate multiple viewpoints, create quizzes and all that. As you know, we are not just deliverer of content, but we should be facilitators of reasoning. In conclusion, we know very well that AI, stopping it is impossible. We cannot police AI. Therefore, what I'm proposing is that we adopt responsible use, which is the only sustainable path. I leave it there because of time. In my paper, I'll capture the implications for our diploma programs, LLB programs, ATP programs, and our call for the the Council of Legal Education, especially the Quality Standards Department, headed by Madam Konuche, that we need to have a national framework for responsible AI use. We need to update our accreditation standards. We need to have guidelines for AI disclosure and citation, and reform by examinations that emphasize reasoning and not recall. Thank you, colleagues. Have a good evening.
We can do better for Mr. Gekombe. Asante sana. AI is with us. Mwalimu Konuche, si juzi tuliona an AI generated judgment somewhere. Kweli urongo? The lawyers, am I saying anything new? Si tuliona AI generated decision? Aya, sio mimi. As a neighbor of mine told me that. Anyway, Mr. Nyaika Hillary. Bonsoir, ça va? Bienvenue. You have 10 minutes to dazzle us and bubbles us, as PLO says. Yeah. Thank you.
Good evening. Thank you so much, Mr. Evans. My research paper is about AI. First, I would like to thank the speakers who have talked about AI, because AI is with us. My topic is about integrating artificial intelligence in legal education. First, my name is Nyaika Hillary. I'm a student at African Nazarene University. First, let me start with a quote from Other Ash who once said that success is a journey, not a destination. AI was really born early enough, but it has gradually been improving towards the 21st century. that it has now been exploding. We are now having to its advantages or disadvantages, as we can all be going to see about. We all know for the past year and 2 years, the extent that the AI has brought, for example, in our country, Kenya. We know how the youth have really embraced the use of AI in what they are doing. It is evident that we cannot run away from reality. It's only, reality cannot run away from us. It's only us who can run away from the reality. And the reality is that AI is here with us. What do we really need to do to the reality that we have today? In the integrating of artificial intelligence in the legal education, we have to come up with a system, the one that the key speakers from the morning have been coming about, the improvement of our legal education. How are we going to cope up and include, how are we going to bring about the artificial intelligence, including in our legal systems? We wanted to promote the ethical learning, including the legal etiquettes, and giving out creativity, and thus enabling us to have that competence and the competence of having a Kenyan lawyer towards the world market. Kenya's legal education has historically placed a strong emphasis on the memorization and doctrinal analysis. We all have to move from the colonial period eras, the type of education that we all have been experienced, to have a new, a reformed education that is going to work towards the generation that we have. We all need to come up with what AI can be able to bring us to the extent that we all have to AI-driven tools that will enable us have a successful and easier time in working of our throughout practices of our life. The objective of the tools will be addressing the challenges that we have been facing, for example, the data privacy, the access to justice, and the algorithmic biasness. We know that we all need to have the extent towards which AI is going to help us. We are not bringing it, not that to replace us. It's only here that we all have to work with the best aspect that it is here to help us to cope up and move forward. Out of the research done, like from example, the CLE, it is evident that technology of the learning institution of our undergraduate and postgraduate programs really have no context or have no much about the ethics of AI. This is because it has not been in a topic of discussion. It's now a topic of discussion because it is here with us and it's in a way having its way into our everything that we are doing. That is why we are coming up that we need to integrate it so that we can understand the way forward that we all need to move about. In a survey done, it has explained that AI technologies, in a way, it might help us in the effectiveness that we'll have towards our case and the backlogging of our case in courts. So this is why we have to come about with a system that is only working in a way that AI will be here to enable us have the efficient and the free and a systematic way of having the integration of the legal education and how it can effectively work towards our advantage, not towards our disadvantage. As I finish, I want that in integrating AI in legal studies and legal education, it equips us with the lawyers to know with extent the introduction of the criminals that has gone towards the extent that we need to understand how they are being formed. So that we all need that innovation in the legal society, in the legal profession, to know that the crimes are drastically and continuously changing from one extent to another. So we need always to be at the mark. If we want to solve something, we need to be always to understand what we want to solve. By mandating reforms like the AI ethics in curriculum and fostering partnership, we all can ensure that we have to be a just for equitable justice in our society. So in short, the AI integration in the legal education is here to help us in integrating on how to understand what really are missing in the present scenario that we have the integration of AI. Thank you so much.
We are not doing it the right way. How did you agree that we clap? Santi sana. Dr. Caroline Maura. Dr. Maura will be presenting her paper, Regulating the Use of AI in Kenya's Legal Education Sector. Welcome, Dr.
Good afternoon. Good afternoon, all. As we have been informed, this is the title of my presentation. The form that it is going to take is that it's going to identify the uses of AI in the legal education sector in general, and then it's going to look at the possibilities for regulation based on the African Union continental strategy and also our legal response here in Kenya to the use of artificial intelligence. I'll begin by putting this in context, i.e. the use of artificial intelligence, by mentioning that we are in this context that has been mentioned by previous presenters, where the use of AI is inevitable, and in any case, it is intended to develop, i.e. our legal education sector is intended to develop a responsive student as they join the legal profession in dealing with AI that is already in use there. So if you note in my first slide here, the presentation studies the use of artificial intelligence in two contexts of the legal education sector in Kenya, with a view to proposing how to appropriately regulate it within the context that I've mentioned, that are teaching and learning. Learning institution policy gaps in the use of AI in Kenya are the basis for this study. So these are examples of AI use in teaching and learning today. So they are already in use or potentially will be used. That's transcription of audio to text to create notes, which we have seen even in meetings that we attend today, in marking of exams, and even in writing essays and dissertations. The third use is certainly problematic and was addressed in a previous presentation. And therefore, by the end of this presentation, I will be presenting possible approaches to regulating its use through the legal education sector in Kenya through institutional policies. We'll be finding out as we go along that in terms of the law regulating the use of artificial intelligence use, there is some response. However, this is yet to be seen in application through case law. So we can begin by having policies that respond to the use of AI, as we also enforce laws in Kenya that already speak to the current state of affairs in the legal education sector. So we are noting here that teaching a globally competitive lawyer today entails preparing them for a profession that has increasingly adopted and is projected to continue adopting AI use. Perhaps we can look at the three issues legally that are bound to come up in terms of privacy, copyright, and access to education, in terms of the use of AI in teaching and learning. So the use of AI in teaching and learning brings about concerns to do with privacy, because AI uses the information that users provide on it in order to continue developing. So there are issues here about to what extent should AI have access to the user's data in the form of what they give in form of information to prompt the AI in order to continue developing. With regard to copyright, there are issues to do with use of work that is protected by copyright in order to develop responses that are given in the learning and teaching context. So this also presents a concern with regard to protection of intellectual property rights in that regard. Thirdly, with regard to access to education, there is the element of what happens to students who do not have access to AI tools in order to approach learning in the context that is coming up today. On to the next slide now. I note here that the African Union's Continental AI Strategy proposes enactment and full implementation of laws in a number of areas, among them intellectual property, data protection, cybersecurity, and consumer protection laws to enable responsible and just use of and development of AI in Africa. So when you look at intellectual property, data protection, cybersecurity, and consumer protection laws, we'll be seeing how these have been addressed in our Kenyan context through the law. Our constitutional response, which I will come to shortly, provides for the rights to privacy and education. It also provides for promotion of the intellectual property rights of the people of Kenya. Then, the Constitution also provides for consumer rights, specifically protection of consumers' health, safety, and economic interests. So if we look at Kenya's Data Protection Act, it provides for protection of privacy of data subjects by data controllers and processors. Therefore, owners of AI tools may be held accountable for unauthorized disclosure or use of data subjects' data contrary to the provisions of the Act. The Act also provides for the right of data subjects not to be subject to a decision based solely on automated processing, including profiling, which produces legal effects that concern or significantly affect a data subject. This is an important point to note as we consider what it is that artificial intelligence can do in terms of creating a profile of its users and leading to issues such as discrimination in content that it provides later on. So in terms of this regulation that is provided under our Data Protection Act, it remains to be seen how this would then be implemented. However, the enforcement of the law should certainly lead us to a place where there is controlled profiling that is, or rather there is profiling that is based on this technology. It's important to note here that the nuances that are there when it comes to human reasoning need to be integrated in the work that is there in teaching and learning in order to produce more responsive approaches to the methods that are there for different learners within the legal education context. I thought it important to mention that here so that as we are looking at these regulations, we have that at the back of our minds. And then when you look at Kenya's Copyright Act, it provides for liability of internet service providers in various circumstances where copyright infringement is enabled by an ISP. In 2025, an ISP could include AI that is used as a search engine. So this is an important context within which to consider regulation of AI in our context in Kenya, where copyright law has responded appropriately by holding ISPs liable for copyright infringement that takes place through their platforms. Then turning to Kenya's Computer Misuse and Cybercrimes Act, this one criminalizes unauthorized use to a computer system as an offense. In terms of responding to AI's use, certainly this creation of the offense would respond to AI deriving information in an unauthorized manner using all the AI tools that are there. Sometimes it's the case that AI will disclose some of the, or owners of AI, developers, will disclose to what extent artificial intelligence can be used. However, there are some gaps in terms of even those terms and conditions that are provided for users. And this is where these concerns are that the law seeks to address thus far. If only it would be implemented as I have recommended, it's possible that regulation of AI use in Kenya in this sector could be effective. Additionally, regulation in institutions through policies that require disclosure when AI is used in activities such as essay writing and marking is important. Secondly, regulation of the percentage of AI use in essays and research papers would also respond to the current context where generative AI is increasingly being used, whether in unauthorized or authorized contexts. Finally, policies regarding AI use have been implemented by some learning institutions in Kenya, South Africa, Europe, and the United States of America, and these provide a basis upon which learning institutions in Kenya, even from the legal education sector, can draw upon as we look at how best to regulate the use of AI in our sector in Kenya. Thank you.
I wish Mzee Moi was here. Moi used to speak to you and you stand up. You've been sitting for a while, apart from my boss, Professor Odote, and the CEO. The rest of you, muamuke muchamuke kidogo, mmekaa sana. Dakika tu moja, and you do the Moi clap. Tafadhali, tafadhali, you have been sitting. So let's do the Moi clap. Moja! Funga! Fungua. Asante sana. To my instructing bosses, CLE, we have kept 1 hour. Thank you very much. It has been a pleasure. And being the teacher that I am, allow me to take 2 questions, male and female, before we leave. Short and precise. I see a hand there. That's male. I need a female.
Check.
Male and female. I see my good friend Kasoa. So let's start with Council Kasoa. Then we go to the gentleman there. Short and precise.
Instructions taken. Thank you, our presenters. My question is this. You have given us good content. Recently we had a discussion and somebody said, we are producing lawyers. Yes. Are we producing producers? Law is a service industry. While AI is here, technology is here, all good these things are here. Do we have agriculture? Do we have Medicare? Do we have environment? Where are these lawyers going to apply this technology? Thank you.
Ms. Kasawa, who should answer your question?
I think but I think Munoko can.
Munoko? Okay, thank you. Then the gentleman in a suit, where is he? Yes, short and precise.
Hello. Thank you very much, Program Director. My name is Ivan Ngoru. I'm from Uganda. I teach at Makerere University. My question is, this is with respect to interventions on how to fairly and justly incorporate AI in our teaching. And my concern is on the proposal to have oral examination and in-person verification of the learner. I wanted to ask, how do you deal with the large numbers following the liberalization of legal education? Thank you.
Dr. Moore, I think that's a good one for you. So we start with you, Mr. Monoko, Agriculture.
Thank you, Madam Hasoa. You know, when we are dealing with the digitization and AI, one thing we are doing is that, you see, AI, as much as people are saying that AI is likely to kill job opportunities, AI is also likely to create more job opportunities. So what we are doing currently is that when you are studying this AI, it applies a lot. Okay, agriculture, it has gone to a much extent, but as I had indicated before, we have AI that is applicable in criminal law, AI in the field of health. For example, if we apply AI in digitizing, for example, let's say just the traffic system, whereby if you overspeed, maybe you are supposed to go at a speed of 70, and it is digitized, it's by use of AI, when you exceed 70, there is an automatic fine. That one is going to reduce, for example, corruption on our roads. That is how we are applying AI in the legal system to help us resolve the issues. Perhaps, for example, when you're traveling, I'm going to Bungoma, and somebody stops me that I oversped by like 5 km, and now we have to negotiate like for 2 hours, and maybe say, you see, you have to do this, either you go to court or you do what. So AI, if we apply AI in some of these fields, it's going to resolve some of these persistent issues that we have. So AI, when we embrace it, it's going to resolve, to be a solution to some of these problems. I've seen, like, for example, in China, just in finishing, in China, I think they have done the facial AI, facial recognition of everybody, so that when you are a criminal and you are maybe on the radar of the police, when you just pass somewhere, the camera will just highlight you. This is a fraudster, and therefore you will be arrested from wherever you are. So that is the essence of AI. AI comes in to help us, and also in research work. As lawyers, you know, we do a lot of research, and AI comes in to help us. For example, when you are doing submissions, it's not supposed to replace your thinking. It is supposed to help you think further, because we don't want to have a situation whereby you are quoting an existing case as an advocate. Then, or maybe we have a judgment which is AI generated, and it doesn't make sense based on the facts that have been presented and based on cross-examinations. So, in essence, as much as we have AI, some things within the legal profession cannot be replaced. For example, if you're doing a cross-examination, AI cannot do that for you. It is you who can do that and look at the misdemeanor, or the magistrate look at the misdemeanor of the accused person or witness.
Thank you very much, Dr.
I don't know whether I've answered your question.
We will continue after tea. Thank you very much. Dr. Mwaura.
Yes, to answer the question regarding large students' numbers vis-a-vis this being used as, or oral examinations being used as a way to counter use of artificial intelligence, my answer here is that if you consider the progress that has been made in terms of AI tools and even beyond AI, technology in general, what oral examinations would be doing is countering one element of AI use. My thinking is that over time, and as these methods of trying to detect AI use are tested in the market, more methods will be developed as we go along, and not just from human use alone, but even integration between human and technology use, not even necessarily AI. So I think the point that had been made earlier in a previous presentation about open-mindedness insofar as use of these methods, or in terms of teaching legal education today, is going to be really required. I would say a combination of an open mind in terms of integrating new methods that are being found to counter AI use, together with technology and whatever tools might be developed in the tech sector, is going to assist us as we look at managing large student numbers, even if we think about oral assessments to bolster our use of AI tools in assessing them. Does that answer the question?
Thank you very much, ladies and gentlemen. A round of applause to my panelists, Dr. Caroline Mwaura, Mr. Nyaika Hillary, Mr. Jared Gikombe, And of course, our discussants, Mr. Wycliffe Sewe, Mr. Moses S. Munoko. You did not follow instructions. We do it as required. Moja. Thank you very much. I know we have pending questions. I saw yours, sir. We have run out of time. I'll request that we interact with this plenary during tea. I'm very sure that the papers will be published and we will be reading them. God bless you. Tomorrow we start at 9. Registration starts at 8:30. We start our sessions at 9 exactly. CLE behind, any instructions for me? They will be meeting people out there? T, okay. Those are my final instructions, yes? May the good Lord bless you. See you tomorrow. Thank you.
Today, we are looking to having you tomorrow morning for a session. As Mr. Ogada has mentioned, we want to start registration at 8:30 so that we can have the sessions officially start at 9. Her ladyship, the Chief Justice, will be gracing the meeting in the morning. We are hoping that we'll then accord her. I know she has a very hectic and busy schedule, but she has been gracious to allow her presence in this conference because of the importance of what we are discussing. Therefore, I'm hoping that we'll start in good time and then we'll be able to make up for time. Today, I know we have had to rush because of the time that we lost in the morning. So kindly, there's tea. Let's continue to interact over tea. And then let's meet tomorrow. Asanteni.